after vacation, my lord. Any date convenient to you?
Pray for a date in the second week of July, if not inconvenient, second or third week of July,
Better third week, my lord.
except for 21st of July, my lord.
On request of learned senior counsel for the petitioner, which has not been opposed to by the learned counsel for the respondent, let this matter be listed. Putul, next date,
29th of July.
29th of July.
Well, in the meantime, the interim order may continue.
The interim order shall continue till next day.
Well, can it be on 27th or 30th, if not
27 July.
27th, please? Oblige. 27th July. Oblige.
Meet with the Russian. My lord, in item number 47 of today's supplementary list, my lord, in terms of your my lord's order passed yesterday in this matter, we have filed an additional affidavit bringing on record, my lord, the order passed by coordinate bench, my lord. We have filed an affidavit yesterday. So can it be called for, my lord?
Call for the additional.
I have given the list. I'm obliged, my lord.
Also, I beg to mention item number 41, matter has wrongly been listed in the order column. So I pray for listing in the Monday in the motion column.
On request,
41.
Mr. S. Dekar, learned counsel for the petitioner, submits that this matter has been wrongly listed in orders column. It ought to have been listed in motions column, and prays for listing the same in motion column. On 22nd of June, the prayer is allowed. List accordingly.
May I please, my lord? My lord, I pray for listing upon regular second appeal for admission on Monday, my lord. What happened in this case was listed twice, my lord. On one occasion, the other side has took the time, and another occasion matter did not reach, my lord. And my lord, the already execution case is filed, and next date is fixed on Monday, my lord. But 22nd before the executing court, my lord. So I pray it
Okay.
Monday, my lord.
Obliged.
May I please, Your Lord? My lord, I beg to mention item number 15, my lord. My lord, in this case, my lord, one page is missing, my lord. So, my lord, kindly allow me to withdraw with liberty, my lord.
Heard Mr.
M. Hussain, my lord.
M. Hussain, learned counsel for the petitioner, who prays for who submits that since some documents are missing in the instant revision petition, he seeks leave of the court to withdraw the same with a liberty to file afresh after rectifying the defect. The prayer is allowed. This civil revision petition is dismissed on withdrawal with the liberty sought for granted.
Most obliged. Your Lord.
I please, Your Lord. Let me mention item number 20, Lord. Saying, kindly matter may be adjourned for the day and take them after vacation.
20. You have informed the other.
I for the petition also.
Heard. What is your name?
A. Hussain.
Heard Mr. A. Hussain, learned counsel for the respondent, who prays for an adjournment. On what ground?
Yeah, happy.
On the ground of personal difficulty of the conducting counsel for the respondent. Learned counsel for the petitioner does not raise any objection, hence the prayer is allowed. Let this matter be listed. 29th of July.
Can I 20 or 20?
20 July.
They are the interim.
Interim order shall continue till next day.
What's a similar prayer, Lordship, regarding item number 2, Lordship? I am for the caveat also. Matter will come on 15th of July, Lordship. Next week I may have some difficulties, Lordship.
Heard Mr. B. Devri, learned counsel for the cavator, who prays for an adjournment. Mr. B. J. Mukherjee, learned counsel for the petitioner, does not raise objection to the prayer. Hence the prayer is allowed. When?
Immediately on reopening.
15th of July.
You.
Please, Your Lordship. Lordship, I beg to mention 2 IA, civilian RSA in order column. And Lordship, in 1 IA, we have filed condonation in delay. It's a fresh matter, Lordship. Lordship, issue notice may be issued.
It is to be listed first,
Next week, Lordship,
15th of July.
15th of July of next.
With this is Lordship. Lordship, with regards to item 22, we have filed an additional affidavit.
Item number?
22. We have filed an additional affidavit that may come up for the record, Lordship.
You have filed
Yes,
all the additional affidavit.
right, Lordship.
My please, Lordship. Lord, I am appearing on behalf of Senior Counsel R. Chaudhary, Lordship. I have an instruction to withdraw this RSA. In terms of the affidavit I have filed regarding their agreement on compromise settlement, Lordship. That I have filed, Lordship, by way of additional affidavit, Lordship. That is on record, Lordship.
Heard Mr. M.I. Hussain, who submits that a compromise has been arrived at between the parties and therefore appellants does not intend, appellants, how many appellants are there?
One appellant.
Appellant does not intend to pursue this appeal any further. He submits that the terms of settlement which has been agreed between the parties is annexed along with the additional affidavit filed by the appellants. The prayer is allowed. This appeal is dismissed on withdrawal.
Madam, can it be disposed of? The word may be, can it be disposed of? Otherwise, they may take it on.
Disposed of on
Lordship.
IA is closed.
Obliged.
It is a Lordship. Can it be taken up after some time, my lord? I can warn you.
Okay.
Make me know. Lordship, this is a transfer petition, Lordship. We are the defendant, Lordship, in title suite number, your Lordship. Participant of 26, your Lordship. which
What
is
is, what
pending.
is the ground for transfer?
Lordship, what happened, your Lordship? The plaintiff, your Lordship, where is here? It is respondent, your Lordship. Will find your Lordship page 13.
What is the ground for transfer?
Lordship, both the parties are belong to the Lordship Katha district of Assam, Lordship.
Right.
And the plaintiff, original plaintiff is the Lordship is also serviceman there. So he has filed this petition, Lordship, for defamation case, your Lordship, only in Kamrup district, your Lordship.
When is
Only meant for your Lordship harassment. So
defamation?
defamation, Lordship, civil defamation. So parties, your Lordship, there was another case, your Lordship, title is pending in there also. Originally, your Lordship, in respect of your Lordship,
When is the next date?
here, your Lordship, next is 25th of this month, your Lordship.
In this case,
Lordship, 25th. And all are, your Lordship, very poor economic condition, Lordship. They have to travel for 400 in each way, Lordship. So,
where the cause of action has arisen?
code of action, Lordship, originally they are, your Lordship.
What is the allegation? How you defame?
Original Lordship, what happened, Lordship? He was the serviceman of Lordship in Karimganj district, the original plaintiff. So there was a workplace harassment, Lordship. Allegation of workplace harassment by a lady of that Lordship office. He has filed a complaint, she. So, and accordingly, Lordship will find a case 14, Lordship, 14. A committee has been constituted and he was placed under suspension. So accordingly, in that respect, Lordship, then electronic media and all this has covered that incident, Lordship. And the petitioner has already, Lordship, the petitioners, all these things are neither, Lordship. The media has taken bite of that, Lordship, resident, of nearby resident. So only 1 and 3, Lordship, has spoken. That is not defamatory. And all these things, all family members and all these has been entangled in
Lord,
this lawsuit.
Mr. What is your name?
I.S. Borgia,
I.S. Borbhuya, I.A. Borbhuya,
I.H. Borgia lawsuit.
I.H. Borbhuya, learned counsel for the petitioner. This application under section 24 of the Code of Civil Procedure 1908 has been filed by the petitioners praying for transfer of title suit number 37/2026, which is pending in the court of Learned Civil Judge Senior Division number 3, Kamrup Metro, Gauhati, to a competent civil court at Silchar, Kachar. Issue notice to the respondent. The petitioners shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 5th of August. Stop. Considering the submissions made by learned counsel for the petitioners as well as the amendments made in the instant transfer petition, further proceeding of title suit number 37/2026 pending before the Court of Learned Civil Judge Senior Division number 3, Kamrup Metro, shall remain stayed till next returnable date. List accordingly.
Hello.
That is the lordship. Well, here we are challenging sealing the order by which an application under Order 1 Rule 10(2) has been rejected. But my lord, considering the age of the title suit, it's a 2016.
10-2 for striking out or impleading?
Impleading on one person and then as a defendant. My lord, may I propose that while passing this order, impugned order, page 52, the learned trial court has made some observations on the merit of the suit. Although the suit is in the stage of issues and documents. If your lordship
Issues have been framed. No.
no, issues are yet to be framed. But from paragraph 10 onwards, page 54, the learned trial court has entered into the merit and dismiss the application under Order 1 Rule 10. So may I propose that only that much of thing while deciding the suit, the trial court should not be influenced by this order of which is passed for rejecting Order 1 Rule 10.
Okay.
That much without issuing notice, otherwise unnecessary somewhere from outside India. So it will
Mr.
unnecessary.
Athar, learned counsel for the petitioner. This civil revision petition has been registered on filing of an application under Article 227 of the Constitution of India by the petitioners, impugning the order dated 21/2/2026 passed by the Court of Learned Civil Judge Senior Division, Jorhat, in misject case number 50/2024 arising out of title suit number 21/2016, whereby an application filed by the present petitioners praying for impleading whom?
Sardar Sukraj Singh, paragraph 6 of the order, page 52.
He himself has not prayed.
No, he has himself.
Impleading one Sardar Sukraj Singh in the suit, in the aforesaid suit, was rejected. Stop. Mr. A. Dhar, the learned counsel for the petitioners, has submitted that though the petitioners are aggrieved by the impugn order, however, they are more apprehensive about the impact of the observations made by the trial court while rejecting their application in the impugn order, which may have a bearing on the final decision of the title suit. He submits that while disposing of the application filed by the present petitioner for impleading Sardar Sukraj Singh, in paragraph number, which paragraph?
Paragraph 10 onwards.
In paragraph number 10 onwards of the impugn judgment, the court has made certain observations as regards which may have a bearing on the merit of the case, though the
Trial has not been started.
trial has not yet been commenced and issues are yet to be framed. Stop. He submits that the grievance of the petitioners may be addressed by making an observation that the observations made by the trial court in the impugn order may not have a bearing on the final outcome of the trial. Considering the submissions made by learned counsel for the petitioners. No, stop. I have gone through the impugn order as well as other documents annexed along with the revision petition. Stop. Considering the submissions made by learned counsel for the petitioners. This court is of considered opinion that ends of justice would be served if a direction is given to the trial court not to be influenced by its observations made in the impugn order by it and decide the title suit on its own merit. With the above observation, this revision petition is disposed of.
Obliged. Those parties are from outside India issuing notice that it will be
Wise decision.
wastage of time and obliged.
May it please your lordship. Before taking your lordships to the impugn order, my lord, just give the factual background. Now, what has happened in this case, my lord, in the year 2010, the predecessor in interest of the respondents herein, my lord, he instituted a suit, being title suit number 369 of 2010, claiming right title and interest over a plot of land.
Title suit number?
369 of 2010.
Okay.
Seeking right title and interest over the suit land, my lord. And for the sake of brevity, lordship will kindly make a note. We refer to the suit land as DAG number 63. Now in the suit itself, my lord, if your lordship kindly turns to page 336, my lord, that is the plain. 37. Paragraph 2 of the plate clearly admits, my lord, that the defendant, who is the predecessor in interest of the petitioner numbers 1, 2, and 3, clear pleading, my lord, that the defendant also has got 1 kata 14 lacha land covered by old DAG number 64 of so and so. So, my lord, there are 2 plots of land.
One is covered by Doc number 63, the other is covered by Doc number 64. The suit in 2010 was instituted on the ground that I was trying to encroach upon that land and sell that land.
Which land?
That's 63, Doc number 63.
Okay.
Now, ultimately, I filed my WS. I've also filed a counterclaim, my lord. Then the suit was decreed. The judgment, lordship finds at page 70. I'm not troubling your lordships with the entire judgment. Lordship will kindly turn to page 80, my lord.
Just yes.
Discussion and decision on issue number 5, point number 4, my lord.
What was issue number 5?
Issue number 5 was, lordship will get the issues at page 75. Whether the land described in the schedule of the plaint and the land described in schedule C of the counterclaim are one and the same land.
Okay. So it was held.
So it was held that it is held that the two plots of land are different.
So suit was for
Doc
369,
63,
63
63.
and counterclaim was for
64. But in the suit itself, the plaintiff clearly says that 64 is owned by me, my lord.
yes.
There is no dispute. Counterclaim is dismissed, my lord. I am not on that. We have filed an appeal. Appeal is pending. Right title and interest is declared of the plaintiff over the Doc number 63, my lord. Now, immediately thereafter, what the respondents do, my lord, they approach this honorable court by filing a writ petition. Lordship finds that at page 89. Claiming that immediately after the decree, my lord, I tried to encroach upon that land.
63 land.
Doc 63. Now, in the writ petition, I file my affidavit. Enclosing therewith, my lord, the reports which were called for during the pendency of the suit from the revenue authorities. I'll take your lordships to page 205, my lord. This is part of the evidence of the circle officer who had deposed in the title suit.
Yes.
Lordship has got it.
Yes.
On oath, I am skipping the first paragraph. Second paragraph, I have already accordingly went to the spot along with the LR staff, supervisory Kanango and a group of Mondal and demarcated the land with the help of all aforesaid. The facts as narrated in the report submitted by me is my findings as a commission. Along with the report, I have submitted the trace map of the concerned page, copy of the chitta so-and-so of both DAGs separately, which shows also the patradars of both DAGs. I have also submitted a report prepared by the Mandal. Now, this is important, my lord. During my field verification, I have found that both the DAGs are altogether differently situated at a distance of 10 to 20 meters. I want to state that both the DAGs are not adjacent to each other. Why this is relevant, my lord? Because the plaint was instituted on the ground that they are adjacent plots, and I am trying to sell DAG number 63 as part of 64. So the circle officer clearly gives a report that they are separate DAGs at a distance of 10-20 meters. Now, lordship will kindly turn to page 208.
Yes.
This is again a report filed before the court of the Munsif number 2, my lord.
Yes.
May I read, my lord? Honorable Munsif Court directed to measure the land of the plaintiff and defendant and to mention DAG number. The plaintiff, Sri Subhas Devnath, that is the predecessor in interest of the respondents, my lord, filed title suit number 369 in the said court. On measurement of land, it is found that Kheraj Mihati Patta number 15, old 116 new, DAG 63 out of the total Ajmali so-and-so R land of Jalukbari Moja under so-and-so, Sri Subhas Devnath is the patadar of 3.34 R of land at serial number 65. Subhas Devnath is enjoying possession of the land with a RCC building thereon. So, my lord, 63 has an RCC building thereon. Lordship comes to the next paragraph. On the other hand, the defendant Sri Vishnupada Saha is the patadar of 3. So-and-so R of Kiraz Miadi so-and-so, dark 64. Of the same Moja and Sohor serial number so-and-so, Pradut Kumar De, who is the petitioner number 4, my lord, the lawful attorney of Vishnupada Saha is in possession of the land, erecting high boundary wall around so-and-so area of land of dark number 64.
Okay.
So, on the basis of the reports, the learned court of the Munsif records the finding that these are two separate plots of land. Now, upon filing of this affidavit, my lord, the writ petition is withdrawn. Even the circle officer files an affidavit, which your lordship finds at 225. Page 226 is the specific averment of the circle officer.
Okay. Then what happened?
Now, my lord, what happens? He files a fresh suit before the learned civil judge this time, seeking a declaration of right title interest over the same plot of lands covered by 63, and seeking an injunction, my lord, that I should be restrained from entering into DAG number 63 by saying it is of DAG number 64. Injunction is passed. No difficulty. I am not at all concerned. I am not at all affected by that order, my lord.
Yes.
I am not concerned with DAG number 63. Now what happens, my lord? Immediately after getting the injunction, he files an application under 151, saying that I have encroached into the land. Police help is sought for, my lord. Miss case number 338 of 2026 is registered. A police 338 of 2026.
Yes.
That is registered. Police report is called for. The police submits a report that yes, there was some dispute, but we are doing regular patrolling of the area. So the matter was closed. I can take your lordship to that order. That Miss J case is closed.
Miss J case was under 151.
Under 151.
Thereafter?
Now thereafter, my lord, another Miss J case is filed. 519 of 2026. Again under 151.
What relief seeking?
Same, my lord, police help. Saying that I have put a lock and key over the their land and I have encroached. 520 of 2006-26 is filed, my lord, under order 39 rule 2A. Alleging violation of the injunction order.
Yes, thereafter.
Now, my lord, I file an application, Miss J case 521 of 2026, my lord, under section 10 of the CPC, my lord, seeking stay of proceedings. Because ultimately it's the same relief and the appeal is pending. The proceedings are stayed. But, my lord,
Of which title suit? Subsequent.
of title suit, the new title suit 149 of 2026.
Yes.
But, my lord, the miss case number 519 is taken up and by an order dated 14/5/2026, my lord, which is the order impugned. My lord, without hearing the 2A application, without deciding the 2A application, the learned civil judge, my lord, comes to a finding that I have violated the injunction order. I have put a lock and key in the land. And then, my lord, he directs the deputy commissioner, deputy commissioner of police, to go with them, evict me out of the land, and the land is to be identified by the plaintiff. Plaintiff takes the police, my lord.
Where is the impugnement?
Lordship will find that observation at page 305 onwards, my lord. I'm just taking your lordship to 305. In the middle, my lord, the sentence starting with on 6/4/2026. Around 10th line from the top, my lord. to 305. This part of the order dated 14/5.
Yes.
Sentence starting with on 6/4.
Yes.
On 6/4/2026, the opposite parties defendants have entered their appearance in the instance suit as well as Ms. J case number 297. 297 is the, my lord, injunction, order 39 rule 1 and 2. And while order dated so-and-so passed in so-and-so, this court was pleased to extend the ad interim injunction.
2A miscase is stayed, has been stayed.
The entire suit has been stayed
And this order is passed in a state suit.
in a state suit in a miscellaneous application
Okay.
under 151.
You
Now,
will-
Lordship will kindly come to that line. However, despite having knowledge of the said order of this court, the OP defendant number 4, Sri so-and-so, has put locks at the entrance gate of the suit land by breaking the lock of the petitioner's matter. How, with utmost respect, my lord, how the trial judge could have recorded such a finding, my lord, without evidence? 2A is a separate proceeding, my lord. Evidence has to be taken, my lord. It's a finding of fact.
This was alleged.
This was alleged, my lord, and then now I have read the order, my lord. The learned judge says that it is alleged, but Lordship will kindly then turn to page 307, my lord.
Yes.
The paragraph starting with in view.
Yes.
In view of the above facts and circumstances. So he has accepted the facts and circumstances to be correct. In the above facts and circumstances, taking note of the gravity of the situation, the police compliance report dated 6/4/26 submitted in Ms. J case number 338, the petitioners prayed before this court to direct the Deputy Commissioner of Police so-and-so to implement, enforce the aforesaid ad interim temporary injunction order dated so-and-so within 1 week from the date of receipt of copy of the order of this court. By evicting the OP defendant number 4, his men agents by breaking the lock of the gate of the suit land, disputed land, upon being physically identified by the petitioner's plaintiffs.
No, your claim is that you are,
Man, I have been
Possessions.
evicted. I have been evicted from dark number 64.
you have already been evicted.
I have already been evicted. Lordship will kindly take the look at the photographs, my lord. Dark number 63 is a clearly demarcated. It has a building there, my lord.
Now say you are not in possession over 64 also.
I am neither in possession of 64. I am not concerned with 63. My limited prayer was, my lord, that the land ought to have been demarcated and identified by the revenue authorities, which is 63, which is 64. The police is not equipped, my lord. Police cannot go and say which is 64, which is 63, my lord. But the learned court below, he gives the power of identifying the land to the plaintiff. Plaintiff goes and identifies dark number 64 as 63. And I am ousted, my lord.
When?
The exact date somewhere after 14/5, my lord, immediately thereafter. I had filed a petition for recall of the order, but that has not been considered, my lord. My limited prayer, my lord, at this stage, my lord, but since the learned counsel is appearing, my lord, let the revenue authorities go and demarcate which is 64, which is 63. That order should not affect them, my lord. I am not asking today on day one that I should be handed over 64.
Has been stayed on your application.
Suit has been stayed on a stage suit, my lord, it is proceeding. The suit is stayed till the issue is decided. These miscases are decided. And in the meantime, I am evicted, my lord. I am in no way connected with 63, my lord. I may not even contest the suit today. Because injunction is in respect of 63.
But suit can remain stay. 2A petition may
2A petition may be there.
may continue.
Let the court decide the 2A. My lord, without deciding the 2A, how can I be evicted? Learned trial court has relied on a judgment which of the apex court which says that yes, police court help can be given.
So
But that judgment clearly said that
So-
first you have to record a finding.
what is your submission?
My submission is that, my lord, lordship may direct the revenue authorities that at least go and verify which is that number 64 and which is that
Suppose
number
they verify.
Yes.
Which court they will give report?
to your lordships, my lord. Under 227, lordships have ample power. my lord.
No. When 2A is pending, it is that court which should decide whether there is a violation of.
Exactly, my lord. Now, without deciding whether there is a violation, can I be evicted from my land, my lord?
Yes. What is your submission?
Please, your lordship. Before going into the core issues, let us first decide what is the locus standi of the applicant to file this application. Who is he? Pradut Kumar De. We have implicated Pradut Kumar De as the defendant number 4. And now he has filed this application being a constituted attorney of the petitioner number 1 to 3. There is no endorsement in the Wakalatnama that Pradut Kumar De is the constituted attorney. He has filed his Wakalatnama for sale or whom or on what authority. There is a judicial notice has been taken by the apex court in various cases. Kindly see the Wakalatnama.
No, if you are not in possession now.
I'm not in position.
Let him file written objection in this CRP. Let him.
But at least lordship will protect me that no construction, nothing should be done in 64, my lord.
That there is also an ambiguity.
So how is he affected, my lord?
No.
If lordship today protects DAG number 64, how is he affected?
No, is there any indication that they are
Yes, my lord, he has captured it. He is
No, that is not in dispute that the land is in possession of the other side.
Yes.
But is there anything to show that they are going to
They
construct?
might, my lord, I do not know, because they are trying to capture this
Then
land from 2010, my lord.
You can come at any time.
No, I am therefore before your lordship. Lordship will kindly protect me that let status quo be maintained in respect of 64 also.
Protection will be required if there is some apprehension
Appeal is pending.
on some.
Absolute. Lordship will kindly come to.
Let him file the written objection.
Let him file. Lordship will kindly come to page 196, my lord.
Yes.
Lordship sees the photograph, my lord. This is DAG number 63. Then lordship will kindly turn to 201. This is DAG number 64.
It's not clear. Okay. No, his version is required. Let him file
Exactly.
objection.
Let him file. But at least lordship will say that the 64, the status quo as of 64 be required, maintained, my lord.
Okay.
Your lordship, he has no land in 64. I'm showing your lordship
No, but
from.
in the written statement you have admitted.
No, in
Yes,
the
but
plaint
he-
itself.
In the plaint you have admitted that.
Yes, but in the judgment itself, it is observed. Let me show your lordship.
You file written objection.
Kindly page number
You
17.
have admitted in your plaint
Yes.
that the predecessor in interest of the present petitioner has
Land in
DAG number 64. And they are claiming right over DAG number 64.
Yes.
And there is Amin Commissioner's report which shows that DAG number 64 and 63 are 10 to 20 meters apart from each other.
This Amin Commission report is submitted by the circle official in 2015, but they have not annexed the another Amin Commission report.
So there are disputed issues.
I am not seeking a final relief today, man. I am not seeking to saying that today lordship will evict them from 64, man. I am simply seeking a protection that so far as 64 is concerned, let status quo be maintained. If they are in position, they will be.
Status quo will not
harm them. How are they affected?
You are in possession.
Kindly see the page number 17.
You file written objection.
Because they have no land in 64. They have land in 661 whole.
If I have no land in 64, very well, my lord.
You
It is
That does
observed
not
in
mean
the-
he will go and enter 64, my lord.
take this plea. Take these pleas in your written objection. Heard Mr. P.N.
And Dekama.
Mr. N. Deka, learned senior counsel, assisted by Mr. S. Bani, learned counsel for the petitioner. Also heard Mr. J. Deka, learned counsel for. You are appearing
Sole respondent.
two
No, two
respondents,
respondents, sorry.
both respondents,
Mother and son.
learned counsel for the respondents. This application under Article 227 of the Constitution of India has been filed by the petitioners impugning the order dated
14/5/26.
14/5/2026 passed by the Court of Learned Civil Judge Senior Division number 1 Kamrup Metro in Miss J case number
519/20.
519/2026 arising out of title suit number 149/2026, whereby the police help was given to implement the order dated 9/3/2026 by evicting the present petitioners from the suit land.
Not the suit, suit, yes, in the order it is suit land.
Suit land. Learned counsel for the petitioners has submitted that in garb of implementing the order dated 9/3/2026, the petitioners have been dispossessed from their land covered by Dag number 64, whereas the suit land was in respect in
Tag number 63.
Dag number 63 of Dag number 63. The learned senior counsel for the petitioner submits that on strength of the impugned order, the petitioners have already been dispossessed from their land. On the other hand, learned counsel for the respondents what is your objection regarding maintainability? This suit is filed by
Application is filed by one Pradut Kumar Dey, claiming himself is a constituted attorney.
which application?
This petition.
No, my lord, this is
This,
by
this is filed by
Archana De, Archana
Archa-
Saha.
Archana Saha and others.
Archana Chaha, but in Wakalat number Pradut Kumar Dey is mentioned. So who is he? There is no name.
Okay, take this plea. On the other hand, learned counsel for the respondents prayed for allowing the respondents to file written objection in this revision petition and seeks some time for the same. On the other hand, learned senior counsel for the petitioner submits that since the petitioners are dispossessed from Dag number 64, land covered by Dag number 64, at least, and they are apprehensive that the respondents may change the nature and character of the suit land. Hence, a status quo. He prays for granting a status quo in respect of nature and character of the suit land till the pendency of this revision petition. Considering the submission, the prayer is allowed. The nature and character of the land covered by Dag number 64 shall not be changed during the pendency of this revision petition. List this matter again on July. 31 July.
Only prayer, my lord, at least the details of the land lordship will be, it is there in the prayer portion 64, the patta number and moza and everything, if it is quoted now.
Yes. Nature and character of
In paragraph, page 33, my lord. Thirty-three at the top.
land covered by DAG number 64 old, 698 new, patta number 15 old, 122 new, in under village Maligaon, Moja Jalubari, Gauhati.
I'm obliged.
May I please, your lordship? So my senior is on legs before court number 10. Can it be taken up after some time?
Government council is there.
May please, your lordship. Here, impugn order, your lordship will find at page 48. This, may I read, Lord? Page
Yes,
48.
just a minute. Yes.
The petitioner write the petition dated 24/10/2024 filed under section 151 CPC prayed for cancellation of cross-examination of PW1, alleging that on the date of cross-examination of PW1, that is on 12/9/2024, PW1 Abdul Mannan appeared before Advocate Commissioner Nivedita Das for his cross-examination. It is stated in the petition that during cross-examination of PW1, the engaged counsel of the plaintiff, namely so-and-so, was busy with argument in another court, and hence he sent his junior assistant advocate, namely so-and-so, to appear along with PW1 before the Advocate Commissioner at the time of cross-examination of PW1. The plea taken by the plaintiff is that after his cross-examination, he met with conducting advocate and informed his engaged advocate that he denied a question which was asked to him by the conducting advocate of the defendant. The following question suggestion is quoted in the petition. It is not a fact that plaintiff filed a suit stating falsely against the defendants that the plaintiffs have title and possession of the suit land. It is also claimed by the plaintiff that except the aforesaid question, he was not asked any question by the conducting advocate of the defendant. It is further alleged that the conducting advocate of the defendant, instead of asking the PW1 petitioner, who was standing in the witness box of the court, he read in low volume from papers in his hands, and he dictated the Advocate Commissioner to write as per his dictation. It is also alleged that Advocate Commissioner wrote as per dictation of learned counsel for the defendant. The petitioner has taken the plea that he did not hear the dictation which were made by the advocate of the defendant to the Advocate Commissioner. It is further alleged by the petitioner that no document was confronted to him at the time of his cross-examination, and that he was directed to put his signature on the papers written by aforesaid Advocate Commissioner without reading it over to him. So this is relevant, Lord. So without reading it over to him. It is alleged. It is also alleged that PW1 Abdul Mannan put his signature as per direction of Advocate Commissioner. The petitioner expressed his doubt with respect to the cross-examination recorded by the Advocate Commissioner. It is claimed in the petition that Assistant Advocate so-and-so went outside of the court for some time after appearing with PW1 before the aforesaid Advocate Commissioner to attend to some of her urgent work, and she returned after ending the cross-examination. It is further elaborated in the petition that so-and-so, believing upon the aforesaid Advocate Commissioner without reading the cross-examination, put her signature in the aforesaid cross-examination. It is stated in the petition that the certified copy of the cross-examination of PW1 was applied on 13/9/2024, and the same was received on 3/10/2024. It is further stated in the petition that upon perusal of certified copies of cross-examination by the conducting advocate of the plaintiff, it was seen that PW1 admitted the entire defense plea of the defendant. It further alleged that Exhibit A and Exhibit B were exhibited illegally during cross-examination of PW1 by the advocate of the defendant. The petitioner further pointed out in the petition that the Advocate Commissioner did not write RO and AC, read over, affirmed as correct, questioning the veracity of the cross-examination dated 12/9/2024. In the light of the above facts, as alleged by the petitioner has prayed for cancelling the entire cross-examination of of the plaintiff PW1, Abdul Mannan, and has prayed for cross-examination of PW1 through the court. The opposite party in their written objection stated that the contention of petition of the plaintiff are defamatory both against the defendant side and the learned advocate commissioner who stood as a representative of the court. The OP stated that during the relevant time of cross-examination of PW1, advocates, namely Srimati Sonso and Srimati Sonso, representing the plaintiff, were invariably present during the entire period of cross-examination of PW1. It is further replied by the opposite party that the statement of absence of Srimati Meghali Vishwa during the process of cross-examination of PW1 is false and strongly denied. The opposite party has further denied the allegations and accusations brought against the defendant side. The learned counsel represented the petitioner has furnished a copy of the Gauhati High Court Civil Courts Commissioner's Rule 2015, notified on 27/8/2015, and referred specifically to Section 9(8) and stated that the commissioner is duly bound to obtain signature of a witness only after the recorded evidence is read over to him and admitted as correct. I have perused the pleadings and objections furnished in written, and I have also taken into account the verbal submissions advanced by both the sides. Situated thus, I opine that the learned counsel representing the opposite party has rightly pointed out that the allegations brought against the defense counsel is not only defamatory towards him but also towards the learned advocate commissioner who acted as a representative of the court. Also, I am of the view that the conducting advocate for the plaintiff have the right to remain present during cross-examination of their witnesses, and they ought to, in fact, out of their obligation towards their clients, remain present during such cross-examination. Merely taking the plea that the junior assistant counsel so-and-so went out for work and came back before conclusion of cross-examination of PW1 is not a correct stance, but rather it reflects their lack of commitment towards their duty for their client PW1 petitioner. Further, this court is also not inclined to second the plea of petitioner that believing upon the aforesaid advocate commissioner so-and-so put her signature on the aforesaid cross-examination without reading the cross-examination, and so she is unable to give proper answer to it. In my view, even if the court was to believe that so-and-so went out for some time, but it cannot be expected from an active party practicing advocate to put her signature on cross-examination without reading the same. Further, in my view, the allegations leveled in the petition are quite serious in nature, and it was the duty of the plaintiff side to intimate the court about the alleged irregularity at the earliest. Merely taking the plea that certified copy of the cross-examination was received on 3/10/2024 does not explain the reason for delay in intimating the court by this petition. As regards the matter of not writing RO and AC in the end of cross-examination of PW1 by the advocate commissioner, the same cannot be interpreted in a strict manner, as because of the fact that the witness himself and assistant junior advocate voluntarily put their signature in the cross-examination. Thus, the prayer for cancellation of cross-examination of PW1 and to recross PW1 by the court is hereby rejected. Parties shall bear their own cost. So this is the MP in order. Now, Lordship may kindly see that the Civil Court Commissioners Rule 2015, it is in the High Court rules as Appendix 49.
Gauhati High Court. Page number?
Page number 615. I am having, Lordship, 5th edition. starts from 614.
Yes.
Now, relevant rule, your lordship may kindly say rule 9. Page 616. Lordship, go.
Yes.
Role and duties of commissioners. So I am referring from lordship rule 5. From 5 onwards, I am reading lordship. The parties to suit or a case shall produce their witness before the commissioner, and no fresh summons shall be issued in this regard. The court may also ensure the attendance of the witness who have filed their affidavit of examination in chief and refer them to commissioner for cross-examination. A commissioner shall admission oath to witness as per provisions of the Oath Act 1969.
You are plaintiff or defendant?
I'm plaintiff.
Okay. Yes.
The commissioner shall admission oath to witness as per provisions of Oath Act 1969 or any other law or rules in this regard. A commissioner shall record the evidence of the witness either in English or in official or court language. A commissioner after, this is relevant lordship, a commissioner after recording the evidence of the witness shall read over the evidence to witness and obtain her signature, sign or signature, and thereafter shall write ROAC, read over and admitted as correct. No space shall be left above the ROAC and signature of the commissioner. A commissioner shall ensure to obtain the signature and name of the person who may take the thumb impression of a witness unable to sign. A commissioner shall note that deposition is directed and corrected if deposition is typed in a computed or in a typewriter. Now 11, lordship may kindly see. A commissioner shall at the end of the deposition take the signature of the advocates of both plaintiff and defendant who are present at the time of recording of the evidence. So these are two different directions for the advocate commissioner lordship. So one cannot substitute the other lordship. That is my humble submission to your lordship. And if your lordship peruses that cross-examination part I am referring, page 28, lordship. And
private parties are there.
Lordship.
Who is defendant?
Page 33, lordship may kindly say vernacular part, last part of that cross. It is not written there that the deposition which was recorded was read over to the witness.
So what is your submission?
So my submission before your lordship is that until and unless these depositions are read over to the witnesses, it cannot be said, the lordship, that he accepted that contents of the same, lordship.
He was PW1.
He was PW1. In fact, he is the plaintiff. He cannot say that he has lost the suit, lordship, falsely. He will not admit that part. It is apparent, lordship. So that has to be read over to him.
Okay, we are issuing notice.
And that stay order we got. Otherwise, that if
It is your suit.
lordship.
Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Ms. K. M. Kalita, appearing for respondent number 3 and 4. This application under Article 227 of the Constitution of India has been filed by the petitioners, impugning the order dated 21/5/2025, passed in Ms. J case number 76/2024, in title suit number 28/2017 by the Court of London, Civil Judge Junior Division number 2, Sibsagar, whereby the prayer of cancelling the cross-examination of the PW1 under the facts and circumstances narrated by the present petitioners before the trial court was rejected. Issue notice to the respondents. Since Ms. M. Kalita has already appeared for respondent number 3 and 4, no formal notice need to be issued. You serve the copy.
Lord.
The petitioners shall, however, furnish copies of this copies of revision petition along with annexures to the London Government Council. As regards the other respondents, the petitioner shall take steps for issuance of notice upon them by speed post as well as by usual mode within 7 days from the date of this order, returnable on 5th of August. Stop. In the meanwhile, considering the averments made by the petitioners in the instant petition as well as the submissions made by learned counsel for the petitioners, further proceeding of title suit number 28/2017 shall remain stayed during the pendency of the instant revision petition. List accordingly.
Obliged, Lordship.
Yes.
Here in this case, my lord, before going to the merit of the case, my lord, may I submit the facts behind filing of the instant petition, my lord. What happened? The respondent herein has filed a suit seeking a declaration of rightable interest in respect of 2.5 acres of land. The suit has been decreed. When, my lord, in the suit I have filed a written statement objecting their, my lord, part, my lord. However, my lord, the suit was decreed only in respect of 2.5 acres of land. And so far that part is concerned, my lord, the respondent has initiated the execution proceeding. While initiating the execution proceeding, but during the execution proceeding, the petitioner has come to know about the notice, which is at page, my lord, 65, my lord. From the notice to the bailiff, it appears that the respondent has intended to execute the decree in respect of 5 acres of land, giving a boundary which is not tallied with them on the plane.
Yes.
Page 65, my lord. This is the notice issued to the bailiff, my lord. Page 66 is the schedule of the land.
Yes.
The 5 acres of land. And so far the decree was concerned, it was only in respect of 2.5 acres of land.
Where is the decree?
My lord, page, my lord, 40, my lord. Before going to judgment and decree, may I refer the plaint, my lord?
No, let us see the decree.
My lord. In plaint, my lord, it has specifically stated the suit land is 2.5 acres. Page, my lord, 27, my lord. Page 27.
Yes.
Now, my lord, judgment and decree is at page, my lord, 40, my lord. I am not asserting any wrong committed by the learned trial court below in respect of passing the decree. But decree is confined only in respect of the suit land. Page 49 is the, my lord, effective order, and decree starts from page 51, my lord.
Where is the schedule of the land in decree?
My lord. That is, my lord, I have filed a application for certified copy, but I have gone through now, my lord, that is not found here in my lord. Although it is, the decree is here, my lord. I have preferred appeal, my lord, that was dismissed, and second appeal is now, my lord, filed, my lord, against this judgment and decree.
Second appeal is pending.
My lord, that is filed, some defect is there. It has been notified yesterday, my lord. That is to be viewed, my lord. So for the decree.
Now, which order you are impugning?
My lord, that is at page 67. What happened, my lord, in relation to that notice, my lord, to bailiff, my lord, the Nazir has approved the, my lord, visited the, my lord, place, my lord, and intended to, my lord, evict the petitioners from the land, which is not the subject matter of the decree, my lord. Because there are two directives there, my lord, 467 and 466.
Read the impugn order.
My lord. During the pendency of that, my lord, execution proceeding, I have filed a petition under section 47, my lord. 47 is petition is 40, page 47 itself, my lord. And upon hearing the parties, my lord, that petition has been dismissed by observing that the decree will be executed according to my lord. That observation is given. But despite that, my lord, what happened, my lord, in relation to that, the order passed in
No,
11.
where is the schedule in the decree?
Decree, that is not found, my lord. I
And
have
how
got the
decree will be
certificate.
executed?
So one thing may, Lordship may do, my lord. Let it be fixed on 23rd, my lord. Meanwhile, I take the instruction as regards to whether the certificate could be given to me contains the schedule of the land in the decree. Let it be on 23rd.
Heard Mr. M.K. Sharma, learned counsel for the petitioner, who submits that he may be allowed some time to take instructions regarding as to whether the decree contains the schedule of the suit land, and prays for listing this matter again on 23rd of June. Prayer is allowed. List accordingly on 23rd of June in motion column.
Meanwhile, my lord, I may also be permitted if any information is found that may be, my lord, what is the through additional affidavit.
The petitioner is allowed to file additional affidavit if so required after taking necessary instructions.
Highly obliged.
Item A.
May it please your lordship. My lord, I am the plaintiff. My lord, the suit is for declaration and recovery of possession. My lord, I submitted evidence on affidavit, my lord, PW1 as PW3, and he has already been cross-examined. The other witnesses, my lord, one is dead, one is seriously ill. My lord, I could not produce them for cross-examination. Then, my lord, I filed an application under Order 16 Rule 3 for allowing me to adduce evidence of one Shahjalal Sarkar. That has been rejected on the ground that sufficient reason. I have not given the sufficient reason. My lord, the impugn order is at page 44. My lord may come to page 49, my lord.
You are plaintiff.
I am plaintiff, my lord. Page 49, my lord. Bottom, my lord. The list appears to be exhaustively prepared, and amongst them plaintiff already filed chief in examination of
Whose evidence you want to induce?
Shahjalal.
He was not a listed witness.
He is not a listed witness.
Okay, read.
The list appears to be exhaustively prepared, and amongst them plaintiff already filed chief in examination of PW3 Sabarul Haq plaintiff, PW1 Adam Ali and PW2 Suraj Jamal Sheikh, and PW3 only cross-examined. Plaintiff did not file examination in chief of PW Khurshid Rahman before his said demise, nor the examination chief of PW Kadem Ali was submitted. On perusal of petition, it appears that only reason assigned for allowing Shahjalal Sarkar to be deposed as PW is that PW1 Adam Ali is not interested. PW.
Your petition was opposed by the defendant side.
My lord?
Before the trial court, whether your petition was opposed.
No, they have not filed any written objection. Only oral.
Oral objection.
My lord.
Then we'll issue notice.
My lord, in the meantime, my lord, kindly stay the suit, my lord, otherwise it will proceed and.
At what stage? It is your suit.
My lord.
Heard Mr. KKD. learned counsel for the petitioners. This application under Article 227 of the Constitution of India has been filed by the petitioners, impugning the order dated 23/2/2026 passed by the Court of London, Civil Justice Senior Division, South Salmara Mankachar, in title suit number 5/2021, whereby the prayer of the petitioners as plaintiffs to adduce evidence of an unlisted witness was rejected by the trial court. Issue notice to the respondents. The petitioners shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable 7th of August. In the meanwhile, considering the submissions made by learned counsel for the petitioners as well as amendments made in this revision petition, further proceeding of title suit number 5/2021 shall remain stayed till next returnable date.
May it please your lordship. By this petition, we have challenged the order dated 27/5/2026 passed by executing court lordship. Your lordship will find that order lordship page 84 lordship. Whatever lordship, the petitioner respondent as plaintiff lordship brought a suit against the petitioner defendant lordship for right, title, interest and recovery of cash possession lordship. And the suit was decreed lordship. And the petitioner, being a layman lordship, entrusted one advocate to file appeal against the said lordship decree. But lordship, the learned engaged counsel lordship did not file any appeal lordship. But in the meantime, lordship, the decree holder, that is the plaintiff in the suit, has put the decree into execution by filing a execution proceeding lordship. The learned counsel, instead of filing any appeal lordship, appeared in the court lordship for petitioner number 1, 2, 3 and verbally submitted that the petitioner are ready to vacate the suit left. But when it comes to the knowledge of the other petitioners lordship, that is the entire petitioner, they on the next date they changed the counsel lordship and filed appeared with new set of counsel lordship. And in the meantime, they filed an appeal lordship before the learned lordship, the district judge lordship. And since the appeals was barred by time, they filed also a petition under Section 5 of Limitation Act for cornering the delay of 35 days lordship. And they informed the executing court that we have filed a appeal against the decree, some time may be granted lordship. The executing court for 2 and 3 occasion lordship extend time lordship for obtaining the stay order lordship. But lordship, the court of district judge who was adjudicating the appeal along with the petition under Section 5 of the Limitation Act has fixed a long date lordship. And it's just the petitioner.
When is the next date?
Lordship, next date is 25/6 lordship for report. And in the meantime, by impugn order dated lordship, the executing court issuance read to the for execution.
But when an appeal is pending?
Appeal is pending in the court of district judge lordship. Your lordship will find the order.
Okay, thereafter what happened?
Lordship, in the meantime, lordship, by the impugn order dated, the executing court lordship already issued read for execution of the decree lordship.
So you again approach before the appellate court.
The appellate court has already been fixed a date, long date.
You may pray for preponing the date in view of.
The petitioner already pursued that, your lordship, there is an observation of the executing court also in the impugn order that the petitioner has already been persuaded the appellate court, but long date has been fixed. Lordship.
So you approach before the appellate court praying for preponing the date in view of the.
Lordship, they tried, but lordship,
this court cannot interfere.
But the date has, since the date has already been fixed, lordship, did not entertain the prayer of the, they not verbally approached Lordship, not
No,
making any petition.
no, nothing doing in approaching verbally. Have you filed any application?
Lordship, the petitioner filed an application informing the executive.
Where is where is that application?
Petition page 77, not before the district judge Lordship, but in the court of executing court.
No, you have to. You will get relief before from the appellate court only. So you have to approach the appellate court. When appeal is pending,
If your Lordship
When-
please turn to page 84, Lordship.
when is the date?
Date, Lordship, 25/6 for report, Lordship.
And
appellate-
when is the date for before the appellate court?
29/6, Lordship.
You go to the appellate court. We'll direct appellate court to take up the matter.
If they tried, Lordship, but since they.
Where is that trial that you have tried going to the appellate? You
But-
filed something before the appellate court.
Lordship, kindly come to Lordship. Kindly come to page 85, Lordship.
Yes, this is the order of the executing court.
Yes, Lordship. The executing court, the learned counsel for the judgment letter submitted at the judgment letter have been persuading the appellate court for stay hearing of this case so that the order can be obtained. Before that also, Lordship, learned counsel will declare a race of seen the petition height so and so, page 84. By the judgment letter stating that a miscase so and so of the limitation and in respect to the appeal filed against
Limitation
the
has not yet been condoned.
not condoned.
You can file an application under 151 before the appellate court during the pendency of the limitation application. Instead, but this court will not
I am at
invoke its jurisdiction during the pendency of an appeal where you can avail the available remedy.
See, my grievance, Lordship, I have already filed the appeal, but.
No,
there
what is the
But
error in the impugn?
error, Lordship.
There is no error. Appeal is pending.
Yes.
No stay is there.
No.
Therefore, it has been issued.
Pendency of appeal.
How will we interfere in
I'm
the
at the mercy of the court. I'm for the end of justice, some time to extension may be granted on, so that I can get the order from the appellate court and submit it before the, since I have filed the appeal, Lordship, and it was the fault of the council who did not file appeal in time, Lordship. And already the executing court order, your Lordship will find that observation that then we, and the next day we set new set of counsel and showing our willingness to file challenging the impugned decree, Lordship.
Heard Mr. B. Halder, learned counsel for the petitioners. This application under Article 227 of the Constitution of India has been filed by the petitioners impugning the order dated 27/5/2026 passed by the Court of Learned Sevilla Senior Division Kokrajhar in title execution case number 1/2026. 2026. Whereby the executing court has directed issuance of writ for execution of the decree obtained by the respondent side in title suit number what is the titles in title suit number 5/2021. Learned counsel for the petitioners has submitted that after passing of decree against the present petitioners in title suit number 5/2021, the present petitioners engage a counsel. Where is that name of that counsel?
Lordship, paragraph 3, page 4. I have mentioned the name, Lordship.
Namely Mr. A. Mahmood, to prefer an appeal against the impugned judgment, against the decree, against the judgment and decree dated 15/11/2025, passed in title suit number
5/2021.
However, have you filed any complaint against the counsel?
They being the layman, immediately change the advocate, change the counsel.
However, the said engaged counsel did not file any appeal, and rather he appeared before the executing court and submitted that the present petitioners are ready to vacate the suit lands. So thereafter, after coming to know about the filing of execution case, the present petitioners engaged a different set of counsel and to prefer an appeal against the judgment and decree dated 15/11/2025. However, in doing so, delay has been caused, and therefore, along with an application, along with the appeal, an application for condonation of delay has also been filed by the present petitioner. In the said, delay is yet to be condoned.
Yes, sir.
In the said application, notices have been issued and the
Respondent already appeared in.
for what 29/6 is fixed for?
For Lordship, is 76. For hearing,
On
page 76.
hearing on,
Hearing on condonation petition.
and next date is fixed on
9/6.
for hearing on application for condonation of the delay filed by the present petitioner before the appellate court. You have filed for stay of execution. Order 41 Rule 5 application has been filed or not? You don't know.
Because appeal has not has been numbered yet because of the condonation petition. That
Still, you can file. There are remedies away. During pendency of an application for condonation of delay in extraordinary circumstances, you have some avenues. You have not filed anything.
they persuade Lordship, perhaps it was denied, Lordship. I am not
You don't know.
fully aware, Lordship.
Stop. Learned counsel for the petitioner submits that though the hearing on the application for condonation of delay before the delay in preferring the appeal before the first appellate court is fixed on 29/6/2025. However, the executing court has fixed the execution case for submission of report of execution on 25/6/2025.
26.
26.
27/5/2026. 25/6/2026.
25/6/2026. And as such, he apprehends that even before the application for condonation of delay is decided by the appellate court, the decree may be executed and the petitioners may be dispossessed from the decretal land. And therefore, some protection is prayed for. Stop. On perusal of the averments made in this revision petition as well as material, other documents annexed there with, and also after considering the submissions made by learned counsel for the petitioners, it appears that an appeal has already been preferred against the decree which is sought to be executed in title execution case number 1/2026. However, since there has been some delay in filing the appeal, the petitioners have also filed an application for condonation of delay, and which is pending before the appellate court. Under such circumstances, petitioners could have approached the appellate court itself under section 151 of the Code of Civil Procedure, seeking remedy of the stay of execution of the impugned decree during the pendency of the condonation of delay application. As such, petitioners are this revision petition is disposed of with an observation that the petitioners may approach the appellate court for seeking appropriate relief or stay of execution of the decree which is sought to be executed in the execution case number 1/2026 during the pendency of the decision on application for condonation of delay filed by the present petitioner. To facilitate the petitioner in approaching the appropriate remedy before the appellate court, when will you appear?
Within 7 days, Lordship.
For next 7 days, the proceedings of title execution case number 1/2026 shall remain stayed. With this observation, this CRPIO is hereby disposed of.
Highly obliged.
Nobody to assist.
Minor, and the file is also, Lordship will pass it over to
We'll
the
take
time
it up
taken.
after some time. After some.
Hello, it has come. This is a revision against an order of attachment. What has happened, my lord, there was a money suit against me. My lord, there was an agreement for sale of a plot of land which belonged to me. But somehow the sale did not ultimately happen. And the purchaser filed a money suit. And unfortunately, my lord, there was no proper contest on the part of the defendant, your lordship. And the suit was decreed. Against that, we have preferred an appeal, but there was a delay in filing the appeal. And the respondent in the appeal, my lord, who was the decree holder, they have not entered appearance for a pretty long time, but after that, they have entered appearance, but they didn't file any reply to the application for condonation of delay for about 1.5 years. In the meantime, my lord, they have entered appearance here,
And if your lordship recalls, my lord, I made the prayer for condonation. They have opposed. They are saying that now we want further time. In the meantime, in the execution case, they have filed an application for attachment of the property. And we have filed an additional affidavit in the appeal saying that we want to sell the property which I wanted to sell to you and make the payment to you and satisfy the decree. But one of the persons who is PW2 examined by the plaintiff, he is preventing us because every time when a purchaser approaches us, he goes and threatens them so that I cannot sell, and he wants to ensure that the land is sold in auction so that he can manage things.
This matter came up.
Yes, ma'am. That is why I am just saying that your lordship may recall. Thereafter, my lord,
What happened to that?
my lord, thereafter, before we filed an additional affidavit saying all these things that we want to pay, we want to satisfy the decree.
Whether that matter is still pending or disposed of?
Pending. Appeal is pending. Delay has been condoned by Honorable Justice Fukan. Delay has been condoned. Appeal has been admitted. Now, in the meantime, my lord, in the execution case, they have filed an application for attachment because if it is attached and then land is sold in auction, he will succeed in his whole oblique motive. Now, I have come against an order of attachment. And I want this lordship may kindly, I pray that this lordship may kindly issue notice and stay your lordship.
But when the appeal is pending?
Appeal is pending.
Out of the same matter?
No, now I have come against an order passed by the executing court, my lord. Separate order. Lordship may kindly have a look at this order. Page 26 is the order, my lord. I have filed an additional affidavit admitting the fact that if this honorable court is of the view that there is nothing in the appeal and appeal is dismissed, I will satisfy the decree, but kindly allow me to sell the land I have. Because this will fetch
to a purchaser of your own choice.
My lord, that is my whole case. Page 26 is the order, my lord. And this has been done by them, my lord, after my learned friend appeared for the other side and took time for filing reply in the condonation petition. And the next day when the matter was listed, again they wanted time. Somehow the honorable court took up the matter and condoned the delay. My lord. Page 26 is the order. This is the order passing the money execution on 8/5/2026. Case, lordship has got my page 26. Case record has been put up today on strength of petition number so dated today filed under order 21 rule 54 CPC for attachment of the immovable property. I have heard learned counsel Mr. Swenso. I have gone through the report submitted with regard to warrant of attachment of movable property. Learned counsel has submitted that JD is secretly trying to dispose of his property. This is the statement I am opposing. The previous day, my lord, I made it very clear that we want to sell it and pay you the money.
Decree is only for money.
Yes, my lord. Decree is only for money. That's what. Now they say that I am secretly trying to dispose this property in order to frustrate the decree. As such, it is prayed that decree holder that appropriate order be passed for immediate attachment of the movable property, and JD has given in schedule of petition number so. I have gone through the case record. Conduct of the JD has already led to delay in execution of the decree. Considering all the above, prayer of decree holder is allowed. That is, then attachment is allowed. Now, next order is at page 16.5, my lord. I will not read the first part. The last paragraph, my lord. Seen petition number so.
Which page?
Next page, page 27.
Yes.
The next order passed by the learned executive court on 16/5, about a week after the first order was passed. Yes. May I read, my lord? Page 27, the last paragraph only, my lord, I am reading. Seen petition number so filed by the Land Council for the judgment debtor, praying for an adjournment for production of the stay order passed by the Honorable Gauhati High Court in the appeal, my lord. They are referring to the appeal. The record reveals that while order dated 10/4/2026, further adjournment for filing of the stay order had already been rejected by this court. Hence, the said petition stands rejected, fixing so for report. Means Nazir will submit a report. And then the page 28, lordship will kindly see the attachment notice, my lord.
No, you are impugning mainly the order of issue.
My lord, I am impugning the order of 8/5
8/5.
and the subsequent order of 16/5. And this is a unique case where I am saying that I want to pay you money, kindly allow me to sell the property, because if I sell the property, this property will fetch double the amount mentioned in the decree. But he is not allowing, and I have made a affidavit with which I filed in the appeal, my lord. I have annexed here. There I have made a specific statement. If your lordship kindly goes to page 18. I'll just read one paragraph, my lord. There are 8. Page 18, my lord.
Yes.
That in view of the above, the appellant has filed the additional affidavit in order to bring to the notice of the Honorable Court the aforesaid facts and circumstances. The appellant further begs to state that in the event this Honorable Court, after hearing the parties and upon consideration of the pleadings and the evidence on record, is not inclined to set aside the impugned judgment in decree, and consequently, the appellant is required to pay the amount of decree as may be determined, adjudged by this Honorable Court. The appellant has no resources to pay the same. However, the appellant, being desirous of selling the suit land, offered to sell the same to third parties, but as and when the appellant initiates a negotiation with third parties for sale of the suit land, the respondent, particularly the said Ashim Das, PW2, has intervened and intimidated the prospective buyer so that the appellant cannot sell the suit property. It is in this context that the appellant has been compelled to bring these facts to the notice of this Honorable Court so as to pass appropriate order or direction in this regard for the ends of justice. This additional affidavit, my lord, I filed in the appeal, mentioning the conduct of the decree holder, my lord. And the decree holder is a person.
If your appeal fails,
I'll pay.
you are ready to pay by
Yes,
selling it.
in fact, my lord, I cannot.
You know the fate of your appeal.
Yes, my lord. Because
so you want to sell it now.
My lord, evidence was not adduced. So to what extent I'll succeed in the appeal? At least we have instructed, my learned has instructed the client that.
Heard Mr. D. Majumdar, learned senior counsel, assisted by Mr. D. Majumdar, learned counsel for the petitioners. This application under Article 227 of the Constitution of India has been filed by the petitioner impugning the order dated 8/5/2026 and 16/5/2026 passed by the Court of London, passed by the Executing Court of London Civil Judge, Senior Division Number 1, Kachar, in money execution case number 2/2024, whereby the applications filed by the decree holder under Order 21, Rule 54 of the Code of Civil Procedure was allowed for attachment of the immovable properties of the present petitioner. And next date is fixed. Date has lapsed already.
My lord, next step we have found out the order passed on 16/6. Next date is fixed on 6/8/2026 for hearing on petition. We filed a petition for seeking stay, etc. My lord. Then Learned Court Bureau has kept the matter for hearing on that petition on 6/8/2026.
On 6/8/2026. Learned counsel for the petitioner, learned senior counsel for the petitioner submits that the decree sought to be executed in the money execution case number 2/2024 has been impugned by the present petitioner by filing an appeal before this court, and the said appeal in this, though in the said appeal there was some delay, however, delay has been condoned
On 8/6/2026.
on 8/6/2026.
And appeal has been registered as RFA 46 of 26.
And the appeal has been registered as RFA 40/2026.
46.
46/2026. Then the senior counsel for the petitioner submits that in the before the In the aforesaid appeal, the present petitioner has filed an affidavit wherein he has categorically stated that in the event of dismissal of his appeal, the appellant is ready to satisfy the decree by selling the suit land to a buyer of his own choice. However, he also submits that the petitioner also attempted to sell the land on earlier occasion also so as to satisfy the decree. However, whenever he initiates a negotiation with any third party for sale of the suit land, the respondent intervenes and intimidates the prospective buyers. Learned senior counsel for the petitioner submits that the intention of the respondent is to compel the selling of the suit land in auction for satisfying the decree. However, under such circumstances, the suit land will fetch much lesser consideration price than it would fetch if it is sold to a buyer of his own choice by the present petitioner. Under such circumstances, he submits that the impugn order of attachment of movable property of the petitioner is not good in law. Stop. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order. Returnable on. When is the next date?
Next date in the appeal is not fixed, madam.
Execution.
Execution 6/8, madam. I'm just
After that day. 14th of August. 14th of August. Stop. In the meanwhile, considering the submissions made by learned senior counsel for the petitioners, as well as the averment made in the instant in revision petition, the operation of impugn order dated 8/5/2026 and 16/5/2026 shall remain stayed till next returnable date. Please check on.
Lordship, kindly mentioned in a money execution case number 2 of 2020. Madam. May I pray that this may be tagged with the appeal so that it can be threshed out? Both the cases.
Yes.
First appeal RFA 46 of 2020.
Let this matter be listed along with RFA number
46 of 2020.
46 of 2026 on the next date fix.
Deep breath.
Item 10 and item 51.
May it please, Your Lordship.
Yeah.
My lord,
What is 51?
51, my lord, I have filed an application under order 39 for an injunction. I am the plaintiff petitioner. My lord, I filed a suit on the basis of a sale deed, which I purchased in 2005. In 2005, after I purchased, I got my mutation. I was a principal of Kendriya Vidyalaya. My lord, thereafter in 2025, after taking permission from the Town and Planning Authority on 4/2/2025, I started construction.
You purchased the land in 2005.
Madam. and thereafter I got my name mutated also.
Okay.
In 2025, after 20 years, my lord, because after after retirement, my lord, I started construction on a permission granted on by the Town and Planning Committee Chairman on 4/2/2025. Thereafter, my lord, the defendant number 1, who was one of the seller of a plot of land, my lord, he came and threatened during construction. I have started construction and plinth everything is over, my lord. Virtually the first floor is going on. When he came and started threatening all the laborers, don't construct here, don't go for any further construction. And my lord, he went to the Town and Planning Authority on a complaint that not to allow me to start construction. So there was a direction on 4/2/2025 for stop construction. Thereafter, my lord, again the same authority on hearing on 10/2/2025 again allowed me to start construction. My lord, so I was constructing. So when he came on disturbing me and tried to threaten me, dispossess from my plot of land, I filed a suit for right title interest along with a prayer for a permanent injunction and not to disturb me in constructing. So at page 61, the trial court passed that order, my lord. Page 61. Para 30.
Injunction.
Page 61. Your lordship has got it?
Yes.
Para 30. Hence, in light of the foregoing, an ad interim ex parte temporary injunction is partly granted, and an interim injunction hereby granted restraining the opposite party agent from any person acting under him from disposing the petitioner from such and such, or interfering in any manner with the construction of the undertaken by the petitioner on the suit land. So this was an interim injunction given to me. Thereafter, when a notice was issued, after hearing both the sides, my lord, they filed written objection. In the written objection, they have stated, my lord, that there was an objection from their side in the Townland Planning Authority, and the sale deed that they have made in 2005, that was only for some exchange, but they have never filed a counterclaim for challenging my sale deed or anything, nothing of that sort, my lord. Then at page, my lord, your lordship will find, after hearing both the sides, at page 84, the trial court passed an order, and the relevant portion is, it starts at page 89. Para 20.
So that in status quo was
My lord, no,
made absolute.
but my lord, here after hearing both the side, my lord, the court held the prima facie case is in page 91. Prima facie case, the principle is decided in favor of the petitioner. Prima facie case was in my favor. The trial court held it that way, my lord. Thereafter, in discussing balance of convenience, the court held in page 92 that there was a direction for stop construction, and thereafter again an order was passed, subsequent order to start construction again. And that cannot be done by that authority. I don't know from where he got, because I have not gone for an appeal. So on that ground, the court held at page 93 that balance of convenience is not in my favor, it is against them. Status quo should be given. And as regards irreparable loss and injury, though already I have started a construction, and my lord, all my materials are pending, that can be compensated by way of money. So irreparable loss and injury is also not there with me. And ultimately the order was passed, my lord, directing to maintain status quo, and page 96. Para 38. They are restrained from carrying out any further construction, carrying on physical encumbrance, making such and such. So construction was absolutely stopped. I again approached the appellate court, my lord. Appellate court, my lord, again held that prima facie case is there in my favor. That is at page, your lordship will find.
From which order you are impugning?
My lord?
Which is the impugn order?
The impugn order, my lord, the appellate order is the impugn order, my lord.
Page number?
112, it starts at 112. Relevant starts at 113. And my lord,
it upheld the trial court's order.
Trial court's order saying prima facie case is with them, with the petitioner plaintiff, But because there were two orders, one on 4-2 and 10-2, my lord, they have not gone for appeal. So, my lord, European loss and balance of convenience is not there. But as regard, and we discussed Dalpat Kumar of 1992 and others, page 134.
Okay, we'll issue notice.
My lord, only one thing, my lord. I want to give an undertaking. If, my lord, if after construction, if I lose the case, there is no counterclaim for cancellation of my sale date. Nothing of that sort. Now going for another 10 years, this suit is pending. I cannot construct. Then all my materials will go, my lord. Everything will be destroyed.
Okay.
And, my lord, this, my lord, I rely on this judgment of 2008 where it says conduct of the parties, my lord. The parties, my lord, they have not said anything, para 21 and 22, that it should be allowed to construct. My lord, because they have no case at all.
No, we'll decide, but two courts have rejected your petition.
But the court has sailed the private facie cases with us.
Court may be wrong. Both courts may be wrong.
But only because the court has.
But notice has to go. So
Notice
wait for few days.
Because if in that alternatively, I just make a small prayer. If I can, your lordship may give a direction that I will make an undertaking and the court will hear the matter and pass a fresh order. I will give an undertaking that if I lose the case, because till now there is no counterclaim, my lord. No, sale deed is not challenged. After 19-20 years, they come and say it is only for an exchange.
Since when it is stayed?
My lord, stayed, that order of stay was?
Original stay.
Original stay, my lord, that was passed.
By the trial court?
Trial court, 10-3-25, my lord. Not 10-3, it will be.
You have waited
21,
for long.
21-24.
No, Mr. P.K. Roy Chaudhary.
My lord.
You have waited for long.
My lord, I understand.
Wait for a few more days.
My lord.
Heard Mr. P.K. Roy Chaudhary, learned senior counsel, assisted by Mr. N. Hawk, the learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner impugning the judgment dated 10-4-2026 passed by the Court of Learned Civil Judge Senior Division Dorong, Mongolday in Miss Appeal number 8/2025, whereby the order dated 14-7-2025 passed in Miss J case number 26/2025 by the trial court was affirmed and the appeal was dismissed. Issue notice to the respondents. The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order. Returnable on 7th of August.
That will be too far because in the meantime, all my cement, all my rods, everything will be destroyed.
But it is there since 25.
Not 25, but 26. It is 14? 14-7-2025, my lord. 14-7-2025.
Almost 1 year.
My lord,
Your cement and rod.
Now, my lord, because during the pendency, because there was no other way around.
In 1 month, nothing will happen. Till 4th of
Let
August.
me in July, my lord, after opening, just after opening.
31st July.
30.
In
I
also notice.
I also, my lord.
Issue notice.
All right.
May I please your lordship? That the plaintiff file a suit for right title interest and for confirmation of possession and cancellation of sale deed. And the suit is, my lord, at the stage of filing evidence by the plaintiff. But several occasions taken time not filed, and thereafter, my lord, they filed a petition under order 7 and rule 14.3 for acceptance of original document. At the time of filing, that was not filed, my lord, originally. That's why, my lord, the case is, my lord, the defendant, my lord, it is, my lord, fixed for objection hearing on 15-7-25. On, my lord, in the meantime, my lord, plaintiff taken twice, my lord, time. I am the defendant here, my lord. But the, my lord, impugn order, my lord, as 48, page 48, my lord, of page 48, impugn order, page at 48. It is stated that the defendant had taken time. That's why, my lord, that the prayer made by the defendant on that death, my lord, for adjournment, that was rejected. 48, my lord, page 48, annexure K. My lordship may kindly.
Yes.
Yes, my lord. Today is fixed for hearing. Parties are represented in the petition number 85 filed by the defendant side, praying another date for hearing.
What hearing? Final hearing.
My lord.
What hearing? Final.
My lord, hearing on the petition of my lord, Order 7, Rule 14C.
Okay.
My lord, that what observation measure? The present petitioner number 53425 has been filed by the plaintiff under Order 7, Rule 14.3, read with Section 30 and Section 150 on Code of Civil Procedure, praying for acceptance of certain original document at this stage of the proceeding and appropriate order heard, and learned counsel for the petitioner, despite granting multiple opportunities, the opposite parties have failed to advance argument and have already availed more than 3 adjournments. Hence, the court inclined to dispose of this petition on merit without granting any further time, my lord. Your lordship may kindly come to page 40, my lord. Page 44, my lord. Page 44. Page 44, my lord. Order dated 29/11/12. Parties are represented today is fixed for hearing, seen petition number 1206 filed by the plaintiff side. Time for hearing heard and allowed fixed on 16/12/25. Next date also, my lord. Page 45, annexure H, my lord. Both sides are represented today is fixed for hearing, seen petition number 120 filed by the plaintiff side, praying for another date of hearing. Thereafter, next date, my lord, PO is on, my lord, restricted holiday, 17/1, and next date, share put up and fixing 23/4/26. What 24/3/26? My lord, 23/4/26. It is, my lord, the purpose finding.
When the petition was filed?
My lord, petition was filed, my lord.
On which date the petition?
Yes, my lord. The petition was filed, my lord, that annexure, my lord. It is, my lord, annexure C, my lord.
No, on
19/5/25, my lord, annexure C, page 32.
19/5/25.
Yeah, that was filed on that.
So from 19/5/25, you have not taken any adjournment.
I have not taken. That, your lordship, the order I have given, my lord, because earlier.
No, these orders are in the month of November only.
Yes, my lord.
In 19/5/25.
The order what I have been given, my lord, your lordship may kindly pause page 14, my lord.
Page number?
Page 14. Page 40, annexure D. Both sides represent today is fixed for PW's evidence. Page 40, my lord.
Yes.
The lordship has got. Plaintiff has filed a petition bearing so under Order 7 Ruliman on, my lord. On that day, that was, my lord, recorded 18/6/25. Fixing 17/5/25, my lord. And thereafter we file objection.
Which petition? Petition number 534.
Yes, my lord.
534 was filed on 18/6.
19/5/25, my lord. 19/5/25. Yes, my lord. It is petition number 534/25. 18/6/25, my lord.
18/6 was the date of filing.
Date of filing as written 19/5/25,
But it
my
was
lord.
put up before the court on 18/6.
Yes, my lord.
Thereafter,
Thereafter, my lord, we
15/7.
file objection. we have filed objection. And my lord, it is Annexure D page 44. That has recorded that both sides is present. Today is fixed for PW evidence because they have not filed PW evidence long back, my lord. Several occasions. Since petition 528/25 filed by the plaintiff side prayed for another date for examination shift, heard and allowed. Plaintiff also filed petition under 534, petition number 534. That petition is filed, my lord. 534, that petition was filed, my lord, that was recorded. Annexure D page 40, dated 18/6/25. Fixed 15/7/25 for objection hearing. Next, my lord.
Okay. Now what do you want?
My lord, the only thing is that, my lord, while I have not taken time, but it was recorded as, my lord, that's why only prayer, my lord, let the defendant hear, my lord, and pass the order, because without leave of the court, they cannot file any original. That is, earlier occasion, my lord, order 13, it was clear, it has to be filed. It has to be filed before issuance of the, but order 7, it is clarified that order 7, it clarified that, my lord, that cannot be filed, that shall not file without leave of the court. That's why, my lord. Because, my lord, if the advocate, my lord, if the.
So first, after filing of written objection by you.
Yes, my lord.
The first date for hearing was 29/11.
Yes.
On which date the other side took adjournment. Other side took adjournment.
Other side, my lord, annexure, page 44, my lord, ordered the 29/11/25, ordered page 45, annexure is 16/12/25.
Also the plaintiff took adjournment.
Plaintiff took adjournment, and thereafter case was fixed on 22/26. That day was, my lord, PO was on restricted holiday, and thereafter on, my lord, 23/4/26. That was, my lord, share put up, where I have taken consecutively another. Because your writing itself says that he has prayed for another time. Where another time? That record does not show, sir.
You prayed for time on 23/4, where you
I have 23/4, I have prayed for time only for the first time, my lord, for objection hearing.
Okay.
That has been that petition 85 filed by me, by a defendant, for an earlier occasion, my lord.
So after rejection of your adjournment prayer,
yes, my lord,
whether you were heard or not?
No, I am not heard. Lordship may parties are represented. Parties are represented by the filing an adjournment petition. So adjournment, as because there is adjournment petition, my lord, so he was not. Adjournment petition has to be heard. Yes.
Okay. Heard Mr. C. Goswami. Learned C. Goswami. Learned counsel for the petitioners. This what will happen about the notice?
My lord, notice, my lord, lordship may dispose of
as the order sheets are apparent.
My lord. Yes, my lord. Or dispose of here after hearing, my lord, they pass appropriate order, or my lord, notice and further proceeding may for the time being.
You are defendant.
I am defendant. Further proceeding may stay for the time being, my lord.
This application under Article 227 of the Constitution of India has been filed by the petitioner Muhammad Abdul Samad, impugning the order dated 23/4/2026, passed by the Court of Learned Civil Judge Junior Division Number 2, Dorong Mongoldoy, entitled suit number 57/2018, whereby the application filed by the plaintiff under Order 7, Rule 14 within bracket D, within bracket 3, read with Section 30 and 151 of the Code of Civil Procedure, was allowed by the trial court without affording any opportunity of being heard to the present petitioner. Stop. Mr. C. Goswami, learned counsel for the petitioner, submits that while passing the impugn order, the trial court has observed that despite granting, within inverted comma, despite granting multiple opportunities, comma, the opposite parties have failed to advance arguments and have already availed more than 3 adjournments. ये लाइन पढ़ दो. Stop. He submits that this is a perverse finding by the trial court. In fact, it was for the first time on 23/4/2026, the petitioner had prayed for adjournment for hearing of petition number 534/2025 within bracket under Order 7, Rule 14 within bracket 3, read with Section 30/151 of the Code of Civil Procedure 1900 bracket close. He submits that the petition number 534/2025 filed by the petitioner plaintiff was put up before the trial court on 18/6/2025, and next date was fixed on 15/7/2025 for filing written objection and objection hearing. Stop. He further submits that accordingly, the petitioner filed his written objection on 14/10/2025, and next date was fixed for 29/11/2025 for objection hearing. Learned counsel for the petitioner submits that on 29/11/2025, it was the plaintiff who filed a petition bearing number 1206 seeking an adjournment, which was granted by the trial court, and the next date was fixed on 16/12/2025. He further submits that on 16/12/2025, the plaintiff again filed an adjournment petition, which was again granted by the trial court, fixing 17/1/2026 for hearing. On 17/1/2026, the presiding officer was on leave.
Restricted holiday on that.
And as such, the matter was fixed on 12/23/2026. On the next date, that is on 23/2/2026, though both the parties were represented, the trial court fixed 23/4/2026 for hearing on the said petition. And on 23/4/2026, the present petitioner filed an adjournment petition for the first time, which was numbered as petition number 85. However, the trial court observed erroneously that it was the present petitioner who failed to advance arguments in spite of availing adjournments for more than 3 times. Learned counsel for the petitioner submits that the petitioner has been greatly prejudiced in denying by the trial court the opportunity of being heard before deciding the petition number 534/2025 filed by the plaintiff. I have considered the submissions made by learned counsel for the petitioner. Since the copies of orders passed by the trial court in the title suit number 57/2018 reveals the veracity of the submissions, reveals that the submissions made by learned counsel for the petitioner is true. It appears that before passing of the impugn order on 2 earlier occasions, adjournment were granted by the trial court for hearing on petition number 534/2024. And on both occasions, the adjournment prayer was made by the plaintiff side only. That is on 29/11/2025 and 16/12/2025. Hence, the observations made by the trial court in the impugn order that the opposite parties have availed more than 3 adjournments and have failed to advance their argument appears to be erroneous, and as such, the impugn order is set aside. With an observation, with a direction to the trial court, when is the next date fixed?
23/6.
With a direction to the trial court to give an opportunity of being heard to the present petitioner and decide the petition number 534/2025 afresh after hearing both the sides. Under facts and circumstances of this case, this revision petition is disposed of at the motion stage itself without issuing notice to the other sides with above observation.
Okay.
Lordship, before going to a consult order, I take my adjournment for the day, Lordship. We request some instructions from the client just to place our objections. So kindly have a short accommodation for the day, Lordship.
Well, we are not objecting, but
Heard, Mr. Item number
12.
Yeah.
heard Mr. A. Iqbal,
G Imtiaz, Mr.
sorry, G. Imtiaz, learned counsel for the petitioner. Also heard Mr. S. A. Bakhtiar, learned counsel for the caveator,
I'm appearing for respondent 3, 4, and 5.
as well as Mr. K. K. Bhattacharya, appearing for learned government advocate, appearing for respondent number 3, 4, and 5. Learned counsel for the caveator. You are appearing for which respondent?
1.
/ respondent number 1. Raised for some time to take necessary instructions and if required to file a written objection against the application made by the present petitioner. The prayer is not opposed to by the learned counsel for the petitioner, hence same is allowed. Let this matter be listed when?
My lord, on 24th, my lord, next week, my lord.
20?
4th, my lord, Wednesday.
No. Next week at the day. Come through. Okay, 24th.
Deeply obliged, my lord.
Lord, item 14 will be taken up similar matter. Item 14 will be taken up. Item 14 will be up.
14.
14.
13 and 14 are same.
Same similar matter. Same matter. My lord, for same suit, my lord, 2 petitions are filed on the Order 711 for rejection of the plaint, my lord. A bogus litigation, my lord, because Supreme Court has said since 1977, Justice Retire, the bogus litigation should be nipped in the bud. Now,
Bogus?
bogus litigation should be nipped in the bud.
Okay.
My lord, that 77 Supreme Court, my lord, is Justice Krishna has said. Now, if you also see the plaint, my lord, because the plaint is it starts from page 29 onwards. I shall place a few paragraphs from plaint, my lord. Your losses may come to page.
Page number?
Page 29, my lord.
Yes.
Now, if your losses comes to my lord, page 39, my lord, page 38, my lord. My lord, originally a farm was there, and that farm was dissolved by a deed of dissolution by para 10, my lord, page 38.
Yes.
Your losses got it, my lord?
Yes.
By virtue of deed of dissolution, dated 1st of April 1974, so insurance. My lord, this is not more. Then now your losses may come to page 39, my lord, para 12.
Can you put in landed properties of were divorced?
So all landed properties were
Covered.
covered. Now, para 12, my lord. That the plaintiffs state that after dissolution of the partnership concern, the plaintiff number 1 and 2 and their deceased brothers, namely Radhesham Agarwala and Rajulbasa Agarwala, at regular intervals for some point of time, used to visit Tinsukia and Lido in respect of their other business affairs. But with the passage of time, they wind up all the business within the Northeast region and permanently next page, settled at West Bengal and started to grow their business within the state of West Bengal and other parts of the country, due to which they had only some casual visit to Tinsukia, Assam. However, since last few years, my lord, so clever drafting, my lord, that nothing has been said. How long? All of them remained absent from visiting the Tinsukia, Assam, due to which the plaintiffs were having no any up-to-date knowledge of the present status of the scheduled properties. There are plenty, this 13. Plaintiffs state that plaintiff remained absent from visiting Assam since long period of time. My lord, virtually in 74, 75, my lord, they have ended up the business and they went to West Bengal. Since last 50 years, my lord, they were not there. And there was no any situation or reason for the plaintiffs to believe that any of the members of the various brothers or their legal heirs, any other person will do any adverse or hostile acts against the right and interest of plaintiffs over in respect of the landed properties devolved in their respective share. However, the plaintiffs in the month of July 2024, my lord, this is after 50 years. After 50 years, my lord, they got there. So there's some reliable sources came to know that taking advantage of long absence of plaintiff, a conspiracy has been hatched up by some of the members of the various brothers who are in an illegal, unauthorized manner
without having any lawful right, title, and interest over the civil properties, negotiating for sale of the civil property with the prospective buyers. The plaintiffs, upon getting information about the hatching of the conspiracy for sale of the civil properties, made inquiry into the matter and approached the defendant number 2 to furnish documents of the landed properties devolved in the share of plaintiff number 1 and 2 and the predecessor of the plaintiff number 3, 4, 5, 6. The former defendants also asked them to furnish information regarding present status of the landed property devolved in their share, but the defendants number 2 avoided to furnish or any share of the documents or information to the plaintiffs. The plaintiff stated that even though the properties were duly distributed among the partners of farm, Assam Frontier Vineyard Mill, all the documents pertaining to the landed property devolved in the share of the plaintiff number 1 and 2, and the deceased brothers remained the office of the partnership concerned at Lidu, which office was mainly looked after by the and managed by the defendant number 2, due to which the plaintiffs were not accurately aware of the details of the particulars of the tag and partner number of the civil property A and B, which have been changed after settlement of the revenue records. The plaintiff states that thereafter the plaintiffs through different sources tried to find out a new DAG and partner numbers of the Schedule A and B property, but plaintiffs unable to test out the same. However, with the constant efforts of the plaintiffs in the month of December 2024, the plaintiffs could be able to test out some particulars of the landed property devolved in their share with full particulars, which were standing in the name of the predecessor, namely Keswara Magarala, in the revenue record. That after much persuasion and efforts made by the plaintiffs, the last part of month December 24, through their engaged counsel could obtain certificate copies of Jamabandi of the respective lands of the Schedule A and B property devolved in the share of the plaintiff 1 and 2, and the deceased brothers, by virtue of the deed of dissolution of partnership, entered among the partners of Agarwala brothers and Beria brothers.
That is of 74.
The plaintiff states that plaintiff are not aware of the Assamese language as such, though the engaged counsel come to know about the entries appearing in the Jamabandi copies of Schedule A and B property, whereby the plaintiffs could come to know that taking advantage of the long absence of plaintiff and their stay in Calcutta, West Bengal, the defendant number 1 to 5, in order to grab the schedule properties under joint conspiracy each other in a legal, unauthorized manner and fraudulent manner, without having any lawful right, title, interest over the civil property or any part thereof, though mutation order dated so and so, and mutation order dated so and so 81, 82, and mutation order dated so and so 82, 82, passed by the circle officer, Margareta Revenue Circle, District Tinsukia, got the name defendant number 1 farm mutated in the Schedule A property, landed 2 bigha 4 kata so and so pertaining to pata numbers of lives. This is now. Your lordships may come to para 19, my lord. Para 19
is 43.
Page 43. The plaintiffs from the revenue record came to know that defendant number 1 to 5 under joint conspiracy each other out of total land of the Schedule A property, taking advantage of mutation entry of the defendant number 1 farm in the revenue record in respect of Schedule A, claiming defendant number 1 farm as owner of the land property, measuring 2 bigha 4 kata 13 lisa, covered under DAG number 57, pertaining to kata number 15. So, a deed of sale bearing number 350 of 2026, dated 12/9/26, sold out the said portion of Schedule A and to the defendant number 3, who is one of the partner of the defendant number 1 farm, thereby an illegal, unauthorized, fraudulent manner, alienated the said portion of the Schedule A in favor of the defendant number 3, which deed of sale is null, void, illegal, inoperative in law, and therefore the same is liable to be cancelled by the dictate of the Sonal Court. Now, my lord, I'm not thinking your lordship may see the prayers, my lord, now, which your lordship will find at page, my lord, 50.
He leaves.
Page 50.
Yes, 50, my lord. A judge A, where, my lord?
Page 50, my lords.
50.
Yes.
Yes, this is a prayer, my lord. A judgment and decree declaring the plaintiffs in promotional defendants number 7 and are having unwetted right, title, interest over the over and in respect to Schedule A and B land. A judgment decree declaring the defendants were having no manner of right, interest or schedule A and property. Judgment decree declaring that the defendants under joint conspiracy to each other got the name of the harm mutated in the revenue records in the schedule B and by mutation number so and so. 81, 82.
And 74 ka wo.
That resolution is to 74, my lord. Then next D. A judgment and decree declaring defendant number 1, my lord, that's self defend, my lord, that's void and to cancel. Then judgment and decree declaring the defendant number 3 has not acquired right title interest in the part of schedule B property on state of deed of sale so and so so and so. Same thing, my lord.
All these are based on the deed of resolution of.
My lord, everything based on the deed of resolution 74, my lord. And virtually for last 50 years, my lord, they were not there.
We will continue at 2.
My lord?
At 2.
Yes.
My lord, item 22 may be taken up the next Thursday, my lord.
Item 22. Request of M. Vishwas, read this matter in the state.
We are jointly praying.
I'm for appeal.
We are jointly praying for adjournment for total lordship.
When do you want?
Lordship, immediately after vacation, 23rd of
No,
July.
no fixed date. On request made by learned counsel for both sides jointly, this matter is adjourned for the day. List this matter after vacation on a date to be fixed by registry.
Lordship, already. I don't know.
Hardly having application order. I see.
Date of the
Date may-
Date.
3rd September.
Lordship, can be before the Lordship.
3rd September. Yes.
My lord, I was placing the prayer, my lord. Now I shall place 2 prayers for law, page 53, my lord.
Yes.
H, prayer H. A judgment and decree declaring that the defendants are trespassers over a schedule A mainland. Trespassers. Rendering the defendants liable to be evicted from schedule A and B land with all belonging. Then judgment decree for recovery of portion of schedule A and B land by evicting the defendants. They are so. So recovery of portion, my lord. We are trespassers, my lord. There. Now, my lord, your lordships may see the impugn order, my lord.
Yes.
Consider anything, my lord.
Where is the impugn order?
My lord, that at 125, my lord. The party so today fixed for necessary order on the petition number so and so filed under order 7 June 11. It appears that the present petition has been filed on the ground that suit is barred by limitation and the plaintiff does not disclose any cause of action. Hard learning counsel so and so, my lord. Now, para 6, my lord. It is further
Order 7, Rule 11, you prayed for rejection of claim.
Yes, rejection of claim.
Okay, on what ground?
On the ground of limitation, my lord, barred by limitation and no cause of action. Now, the lawsuit see next page, my lord. Hard learning counsel so and so. The defendants have contended that suit property originally belonged to partnership farm, namely Assam Frontier Veneer Mill. After dissolution of the said partnership deed dissolution, that is 1474, the parties distributed among the 2 groups, Agarwal brothers and Beria brothers. Further contended plaintiffs remain silent for more than 50 years, and the present suit has been instituted in the year 2024 only after learning about the proposed sale of a property. According to the defendants, the claim based on the deed of dissolution is clearly barred by law of limitation, and therefore the plaintiff is liable to be rejected. So and so. Other plaintiff have filed a written objection denying the statement made in the plaint and contended the suit discloses a valid cause of action and was disputed question of fact required education by of evidence. The plaintiff relied on following judgment, my lord. I am not. Now, your losses may come to para 10. The Honorable Supreme Court in T. Satyapal versus so and so and Salim Bibi has held that power under order 7 can be exercised only when the statements made in the plaintiff appears that suit is barred by law and does not disclose any cause of action. The 77 is, my lord, that is the original judgment. The present case, the perusal of the plaintiff, it cannot be conclusively held that the suit is barred by limitation. Now, this is the question relating to the deed of dissolution, nature of rights claimed by the plaintiff and held is cause of action matters which require adjudication on evidence, whether plaintiff had knowledge of the alleged acts of the defendants, whether suit is within the limitation or mixed question of law and fact, cannot be decided at this primary stage merely on the basis of the application under Order 7, Rule 11 specie. However, the plaintiff discloses certain assertions regarding plaintiff's right over suit property and alleged defendants which primarily constitute a cause of action for filing a suit. Therefore, it cannot be said that plaintiff does not disclose the cause of action. So, in view of the above, court is opinion that ground taken by the defendants for rejection of the plaintiff require detailed examination during trial and cannot be decided this. Now, this is the only for a cryptic order. My lord, in this regard, my lord, I shall place there are a series of judgments. I shall place only 3 judgments, latest judgments, my lord, of the Supreme Court. The first judgment is, my lord, 2020-16 SCC 601, my lord, because earlier judgments were considered in these judgments. 3 judgments, my lord. 2016 SCC 601. My lord, your losses may come to paragraph 6.7.
Yes.
My lord. In Sopan so para 11 and court, this court observed under in ITC, it was held that basic question to be decided while dealing with the application filed under Order 7 Rule 11, the cause is whether real cause of action has been set out in the plain or something purely illusory has been stated with a view to get out of Order 7 Rule 11. The trial court must remember that if on a meaningful and not formal reading of the plaint, my lord, this is very important, my lord. It is manifestly and vexatious and meritless in the sense that not disclosing a clear right to sue, it should exercise the power under Order 7, Rule 11 of the Code, taking care to see that the ground mentioned therein is fulfilled. If clever drafting has created the illusion of a cause of action, it has to be nipped in the bud at the first hearing of the examination of the party searching under Order 10 of the Code. In Madhuri so-and-so, the plaint can be rejected under Order 7 Rule 11 if the conditions enumerated in the said provision are fulfilled. It is needless to observe that the power under Order 7 Rule 11 can be exercised by the court at any stage of the suit. The 11 facts which need to be looked into for deciding the application under the abatement plaint only. If on entire meaningful reading of the plaint is found that the suit is manifestly vexatious, meritless, in the sense that not disclosing the right to sue, the court should exercise power under Order 7 Rule 11 CPC. Since the power conferred the court to terminate the civil action at the threshold is drastic, the condition enumerated under Order 7 Rule 11 CPC to the exercise of power of rejection of plaint have to be strictly adhered to. The abatements of the plaint have to be read as a whole to find out whether the abatement discloses any cause of action and whether the suit is barred by any law. If it is needless to observe that the question as to whether suit is barred by any law would always depend on the facts and circumstances of each case. The abatements of the written statement as well as contents of the defendant are wholly immaterial while considering the prayer of the defendant for rejection of the plaint. Even when the allegations made in the plaint are taken correct on the face value.
No, in this case,
yes.
In this case, the plaintiff is alleging that you have sold a portion of land.
Yes.
And is also praying for cancellation of that.
My lord, that is 2016. That is also. But mutation was done in 81, 82.
And the
But
right
they are
right accrued in under Resolution 74.
no, but they are claiming that they came to know about this.
Came to know how? That I shall place the judgment on that basis. They are if they are sleeping over the matter, my lord, that will not they cannot say that they came to know now. My lord. That is why, my lord, I am placing the judgment. Supreme Court has taken care of all the things, my lord. Even so that barred by law or general institution caution, application for rejection can be entertained and the power under Order 7 Rule can be exercised.
Two things are there.
Yes.
Whether it plain discloses a cause of action or not.
Correct.
So the trial court came to finding that apparently plain discloses a cause of action. As regards limitation is concerned, the observation of the trial court is that
Mixed question of law and fact.
that at this stage, facts are not sufficient to come to the conclusion.
That is why I have read the paragraphs of the plain, my lord. And that is why I am reading the judgment, my lord, how Supreme Court has dealt with. My lord, that is, your losses may see, my lord, that. If they show the suit is barred by any law or not done disclosure cause of the application, rejection of claim can be entertained and power under Order 7, Rule 11 can be exercised. If clever drafting of the plaint has created the illusion of cause of action, well, this is done here.
No,
The
that
court-
is your plea.
That is not the plea, my lord, because they say that we are trespasser. When we have trespassed? 74? They have not gone there, my lord, for last 50 years. We are trespassers, 50 years. Article 65, 12 years, my lord.
No, therefore, the question of limitation has to be decided.
My lord, that is why, my lord, I placed, my lord, a few judgments, my lord, that how Supreme Court has dealt with. Because Supreme Court in one matter, my lord, remanded back by the High Court. Again, it was done. Then Supreme Court has, my lord, again passed it. My lord, plain has been. I shall come to that also.
And cause of action or the limitation. It is not
Both things, cause of action and limitation.
or limitation.
Para 6. In announcing, the court observed and held that when the suit is barred by any law, the plaintiff cannot be allowed to circumvent the provisions by means of clever drafting so as to avoid meaning of those circumstances by which the suit is barred by limitation. Applying the law laid down by this court in the aforesaid decisions in exercise of power under Order 7, Rule 11, the facts of the case in hand, the abatements in the plaint, we are of the opinion both courts or below have materially erred in not rejecting the plaint in exercise of powers under Order 7, Rule 11 CPC. It is required to be noted that it is not in dispute that a gift deed was executed by the original plaintiff himself among the brothers. The deed of gift was a registered deed of gift. The execution of gift deed is not disputed by the plaintiff. It's a case of plaintiff that gift deed was a showy deed of gift, and therefore the same is not binding on him. However, it is required to be noted that for approximately 22 years, neither the plaintiff nor his brother claim at any point of time the gift deed was a deed of gift. One of the executions of gift deed, the brother of the plaintiff during his lifetime.
No, these facts are relevant.
Yes, my lord.
So after 22 years.
After 22 years, they have come, my lord. That is, my lord.
In that case.
Yes, yes, my lord. Now, if you are also, my lord, that also replied, my lord, para 9, that trial court has said. Para 9, next page. Now, so far, application on behalf of the original plaintiff and even observation made by the learned trial court as well as High Court that the question of the limitation is a mixed question of law and facts, which can be decided only after parties' late evidence is concerned, as observed and held by this court in so and so. Considering the abatements of the plaint, it is founded that the suit is clearly barred by law limitation. The same can be rejected in excess of power under Order 7, Rule 11. In view of the above reasons, we have the opinion that both High Court as well as learned trial court are in not exercising the power under Order 7, Rule 11 and not rejecting the plaint in excess of power under Order 7, Rule 11.
No. Plaint must after going through.
They prayed for recovery. They have cancellation of, my lord, mutation, cancellation of the sale deed. Mutation is of 81, 82 and sale deed of 2016, and they claim for recovery. They are saying that we are trespasser. We are trespasser, my lord.
And they are claiming right to property under the 674.
And their right to property is under 74 resolution only. Then we say, I shall place two judgments of 2024, my lord. 2024 18 SCC 426. First. And another one is 2014 15 SCC 675. Well, two judgments I shall place. I shall place. Now, first, my lord, 2014 18 SCC 4 to 6. It is delivered prior to time. My lord, in this judgment, your losses may come to paragraph 9.1 and 9.2 first. Then
Page
paragraph
11.
19.
Page
Page 429. Your losses got it, my lord?
Yes.
It is submitted that suit clearly barred by law of limitation, and therefore the plaintiff ought to have been rejected under Order 7 Rule 11 D. It is further submitted the High Court has not properly appreciated the fact that suit is barred by limitation, as the same was instituted 61 years after execution of the partition deed. That is so.
Just a minute. Mr. Das, what is your contention?
Lordship, here, Lordship,
What is your contention?
my contention, Lordship, is that the projection that has been made is that here there is nothing as on record to show that we are claiming anything based on the 1974 deed of restitution. What we are claiming is what are the events and the documents which happened after the 1974 dissolution had happened. And the last mutation order, they were actually the property belonged to a partnership firm. There were Schedule A property and Schedule B property. Schedule A property was given to the there were two groups, the Bagaria group and the Agarwal group. The first Schedule A property was given to the group that they are claiming they are holding the thing, and the other property was given to us. It was there in the name of my father. Thereafter, what had happened is that we were
Other property was given as per the
deed of resolution. And then thereafter, this property was still in it was in our name only. In 81, the Schedule A of the plane, that in 81, the Schedule A property, it was mutated, and the Schedule B property was mutated in 23. The time frame that has been given, everything that has been read is in a peaceful manner. Here, the plaintiff has to be, again, the plaintiff has, as it has been said, whether it discloses a cause of action, whether there was a limitation.
Yes. Mr. Sahavan, complete your submission.
Now, my lord, now paragraph 19 and 222, my lord.
9.1, 9.2 क्या लिखा हुआ है?
Okay, देखा दिया.
अच्छा.
Paragraph 19, my lord, at page 438.
Please. 433.
433. That paragraph 18 also they have referred to a judgment, my lord. That is also important. Paragraph 18. The Mathuri class so and so. This is a judgment of 2017, my lord, 13. The claim can be rejected.
No, what I was saying, whether we can dispose it of today itself, or will you be filing any objection?
Lordship, subject, if there is a stay, then my suit will be, I am the plaintiff. Because that is my difficulty. That's why I am on KVL.
When is the next date fixed?
21/7. 13/7.
My lord, for time being, my lord, your losses may fix a date, my lord. Till then, my lord, should we stay?
Lordship, your objection to the effect, basically,
I shall place
the law has been placed, Order 7, that has been, the law is well settled, there is no dispute, and it is also well settled that every judgment has to be looked in a given fact.
No, if you are objecting, you bring on record, you file a written objection. Till then, we will keep this suit straight.
Lordship, then again, the delay would be there because here,
1 month,
it can be disposed.
When is the next date?
13/7.
When court is reopening?
13.
So, my lord,
We'll fix it on 13th. Then the question of stay will not come.
My lord, no, on the day case will be there, my lord. On the day case is fixed, my lord. So,
It is
your
fixed.
losses may limited, my lord, your losses may give limited, my lord. 20th of, my lord, your losses will fix. Till then, my lord, only. Till then. The trial court can give the date next, my lord.
Actually, what can be done is that if I mean, what can be done is that let it be fixed on 13. 13, then adjournment may be given there in the trial suit. This is fixed
Because
for today.
the question is very
limited.
Limited question.
Very limited. And I'll show judgments are very limited, and judgments are in my favor, very limited, it can be decided. Because again, if a stay is given, then the point will elongate, and I'm being the plaintiff, the whole purpose will get. So at 13, maybe on 13, I will not say that, I'm not saying that on 13, if there's an adjournment, there'll be a huge dollar. On 13, since both can agree, the 13, let it be fixed.
No,
and then
you will be filing written objection.
My lord,
I can file that.
I think, my lord, it will be
Lordship,
fixed on a hearing day.
Lordship,
My lord, Tuesday or Thursday. My lord, that will be better, my lord, because it will take some time.
we will not be filing any objection because everything is on record.
There
is nothing, because whatever they have pleaded, that has been taken care by the trial court, and
No.
our objection is already there on record.
If ultimately this court comes to a finding that the impugn order is bad, then your suit goes.
No, that is
Therefore, it has.
No, Lordship, what I am
I
submitting.
am giving a fixed date.
Yes.
Fixed date instead of heard Mr. G.N. Sahewala, learned senior counsel assisted by Mr. S. Murarka, learned counsel for the petitioner. Also Mr. R.J. Das, learned counsel for the. How many respondents are
5.
there? All respondents.
Yes.
I am
Very-
appearing for respondent 1 to 5.
Learned counsel for the.
1 to 5.
Number 6.
I am on caveat.
6, my lord, I have 6 documents on the filing. 6, Siddharth Sagarwala.
Parties. Some matter of.
What my response is? Document or cutting? Okay, for
6. 1 to 6. 1 to 6.
And the perform maybe stack of my no problem.
Respondent number 1 to 6.
8 or 9.
This application under Article 227 of the Constitution of India has been preferred by the petitioners, impugning the order dated 16/3/2026 passed by the Court of London Civil Justice Senior Division Tinsukia in Miss J case number 50/2025 in connection with title suit number 15/2025, whereby the application filed by the present petitioner under Order 7, Rule 11, praying for rejection of the plaint on the ground that the suit is barred by limitation was rejected by the trial court. Learned senior counsel for the petitioner has submitted that since the presence of pro forma respondent may not be necessary for deciding the instant revision proceeding, revision petition, the names of pro forma respondent number 7, 8, and 9 may be strike out from the present, strike out from the revision petition. Prayer is allowed. It is agreed upon by both the sides that since a limited question is involved in this case, this revision petition may be disposed of on the next date of hearing. However, learned counsel for the respondent submits that the respondent may file a written objection against the instant petition filed by the petitioner, and hence prays for some time for filing written objection. The title suit number 15/2025 is fixed before the trial court on 13th of July 2026. Stop. Let this case be listed for
Maybe for admission, my lord.
Earlier submission was for final disposal, then it will not be.
The admission will be disposed of.
there.
So it will
or final disposal
final disposal.
Final
Final
disposal.
on which choose a date.
Was it 13 or 14, any date here?
14th of July.
14th of July.
Regarding stay,
Well, till then, my lord,
Again, on 13 that joint prayer of adjournment may be given. That's what I'm praying. No stay may be given at this. That's my prayer. Because here on 13 day,
on the next date fixed before the trial court, the trial court shall adjourn the matter in view of the pendency of this this revision petition before this court, list accordingly on 14.
deeply obliged.
in the next, my lord, 13, same will be there. Only, my lord, here, your losses may, my lord, stack of the similarly, my lord, the Pokemon defender's name. They
You are appearing for
same 1 to 8.
the impugn order,
Same.
title suit,
Same.
title suit also same.
Same, my lord.
Then
because
why
this
to
is
the
another party, my lord, filing. Same. Same
Here petitioners are different.
Petitioner is different, my lord. That is why.
Only the petitioner is.
Petitioner is different.
And whose name will be struck out?
Struck off same, my lord. Pokemon defender's name would be struck off.
No. The pro forma defendant number
Yes.
10 and 9 you are representing in this case.
9 to, my lord, that maybe stuck off, my lord. No problem.
9 to 13.
Same order. Only the striking out portion instead. Respondent number 9 to 13 may be strike out.
7 and 8 also. 7 and 8 to
7, 8.
Rajesh Agarwal and Anjita Bhumpe.
7 to 13 may be
Oh,
strike.
7 to
Yes.
7
7 to 13.
7 to
7
13. Release this matter along with CRPIO number 258 of 2026 on the next date fixed.
deeply obliged.
I did sustain. May I please, Your Lordship? That petitioner, my lord, being plaintiff, my lord, file a suit for a right to OA, my lord. The defendant appear, my lord, and defendant here also, my lord, did not file, my lord. Defendant did not file the original documents, my lord. And, my lord, the petition filed, my lord, for acceptance of documents under order, my lord. Order 8, Rule 1(8)(c). The order, Your Lordship may kindly see order, my lord, 19/5/25, Annexure 8, page 70. Page 70.
Yes. This
Parties are represented.
this order you are impugning.
My lord,
No.
this order is not the impugn, my lord. This order was, my lord, against this order without hearing as such. This order was passed without hearing as such. A review petition was filed by the petitioner, my lord, and will along with the condonation of delay of 29 days. That condonation of delay petition is rejected. Accordingly, review rejected. Your Lordship may kindly next order, my lord. Kindly go to the next order at page, my lord, 80. Page 80. Page 80, both the sides are represent today's fixed for DW's affidavit. Accordingly, defendant one submitted DW1 on affidavit and the same is tagged with the case record. Furnish copy of the said order side. Other side, seen petition 525/20 filed by the defendant number praying another date for remaining DW's affidavit. Heard the petition is heard and the petition is stayed till further order. Plaintiff file petition bearing so has prayed time to file petition for recalling the order dated 19/5/25. I have filed or petition for recalling that earlier order, my lord, 19/5/25, as it was passed without hearing. Prayer was allowed. Heard the learned counsel represent the plaintiff side
allowed the petition. Petition was allowed on that day. Because my lord, the order is on my lord, that 19/5/25 order, it is passed behind my back. That order is uploaded, and subsequently we came to know on the next date. On next date, I filed the petition for praying that I will file a petition for recalling the order, and that prayer was allowed. And thereafter, my lord, petitioner filed a review petition along with condonation of delay of 29 days.
Review of which
A
order?
review of my lord, that for recall the order then 19/5/25 annexure at page 70. Because it was that they have filed petition, and instantly, my lord, on the same date, they have filed petition, my lord.
Okay, thereafter?
Thereafter, my lord, that the impugn order, my lord, your lordship may come to the impugn order, my lord. That impugn order, as page 70, start from page 797, my lord, 23/3/26. Today, the fix for final order, parties are represent. The present petition has been filed by the petitioner plaintiff prayed for condonation of delay along with the prayer under Order 47, Rule 1, read with Section 151 CPC seeking review.
Which page,
Recall the order.
which page you are?
Page 97, my lord.
97, okay.
Page 97. Last order, my lord.
Yes.
Annexure 16, my lord. That page 97.
Your review was
Yes, my lord. Review delay of condonation petition was, my lord, rejected, and accordingly that, my lord, review also rejected. But only thing, my lord, that I have stated the ground, my lord, your lordship may kindly, in the review petition, I have stated the ground in page 89, my lord, is the review. Condonation of delay petition is, my lord, page 88, annexure 13. That ground I have taken, my lord, from page 89, my lord. Page 89, form 4 itself, my lord, that on 19/5/25, defendant filed documents and this honorable court has pleased to accept those document filed orders so and so 19/5/25, that the plaintiff received the copy of the petition dated 19/5/25 filed by the defendant on 17/6/25 and came to know on 17/6/25 about the said fact that the document filed by the defendant on 19/5/25 were allowed, accepted by the honorable and honorable court, and petitioner plaintiff was not informed or get opportunity to file objection. That if these days document are accepted to be proved, and petitioner plaintiff will be highly prejudiced, as such plaintiff evidence and cross have already been closed. That till 12/8/24 the deceased advocate took step in said suit, but defendant did not take steps to file document, though they cross-examined the plaintiff witness, and plaintiff also could not go through the said document at the time of adducing evidence. As such at this stage, after about 8 years since 14/9/17, defendant cannot file the said document, and newly engaged advocate also since 27 to 25 did not take steps. Earlier, my lord, that cross-examination of plaintiff is over, my lord. Even then, lastly, by page 62, my lord, page 62, they're directed to strictly file. Page, for a moment, my lord, page 62. Page 62.
Yes.
Page 62, my lord, ordered at the 12/3/25. Next page is, my lord, origin copy, type photocopy. I am reading here. Case record is put up before me today. Both sides are represented. Defendant are strictly directed to submit their DW's evidence on affidavit before this court on the next date on 19/5/25. On 19/25, there, instead of filing, my lord, evidence, they filed this petition under order 8, my lord, on 19, and that order is instantly, that was allowed.
No,
And-
the trial court did not find the cause shown by you for delay to be just cause.
Well, delay is, my lord, that on 19, petition was filed, my lord, Annexure 7, page 64, my lord, on 19/5/25. Annexure 7, my lord, page 64.
Which order you are
No,
impugning?
my lord, that the petition filed by them by under order 8, my lord. That order, that was filed on 19/5/25. Page 64. On that day itself, my lord, 19/5/25, it was allowed by the court. Court may allow, my lord, that that is the or language is clear that, my lord, otherwise, my lord, court has to file before issuance of the at the time before issue and documents, my lord, and within 15 days as per
that
order 30. However, my lord,
19.5 order is not.
order 8, it is clear, my lord.
But that order you are not impugning.
My
You
lord,
are impugning only.
impugn order is there, my lord. This is the
Impugning the rejection of your
my lord, that is
application for condonation of delay.
condonation of delay order, my lord. Condonation of delay order is impugned, my lord. This is the 23/3/26.
Okay, we will issue notice. We are
My
issuing.
lord, this is a my suit, my lord. Even if we my
You
lord,
are paying for stay also.
my lord, stay, my lord, for period, or your lordship as this, will pray for adjournment, that will be allowed for 1 day. Your lordship may issue notice, my lord. And my lord, even if my lord, dusty service may be given, my lord.
Heard Mr. C. Goswami, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner, impugning the order dated 23/3/2026, passed by the Court of Learned Civil Judge Junior Division Mongoldoy, whereby the review application preferred by the present petitioner for review of the order dated 19/5/2025, passed by the trial court in title suit number 64/2014, was dismissed on finding it to be barred by limitation. Stop. Issue notice to the respondents. The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 7th of August.
Till then, my lord.
Stop.
Because next date is 22/6.
In view of you are praying from Dasti mode also.
My lord, yes.
Alternatively, the petitioner shall also take steps for issuance of notice upon respondents by Dasti mode. Stop. In the event the petitioner is able to serve the notice upon the respondents by Dasti mode, he shall file an affidavit in compliance thereto on the next date fixed. Stop. In the meanwhile, considering the submissions made by learned counsel for the petitioner, as well as the averments made in the instant petition, further proceedings of title suit number 64/2014 shall remain stayed till next returnable day. Please take out.
Oh, please.
Item 17.
Well, this revision petition is against the order passed by the First Appellate Court in which, my lord, we have challenged the injunction order passed by the trial court, restraining us from entering into the scheduled plot of land, and where there is a temple established in the year 2022. It's a community temple. Everyone goes and worship there. So I've been restrained from visiting the temple, my lord. If I may take your lordship to the page 71, Annexure E.
The trial court granted injunction
Granted
against.
injunction in favor of the plaintiff. Then on appeal, my lord, our appeal was dismissed. The basic prayer, the suit was filed praying right title interest over a government land, my lord. Your lordship is aware. The government land, my lord, suit cannot be decreed to the extent of declaration of right title
No, why
interest.
the appellate court dismiss the appeal?
But though appellate court has referred to various judgments, Dalpat, then Antox, then Gujarat bottling, to emphasize on the point that there has to be a prima facie case, which, my lord, is required to be decided first. But interestingly, my lord, though the Gujarat bottling and Dalpat Kumar judgment was referred to, but no conclusion has arrived at by the learned first appellate court as to whether there exists a prima facie case which will go for trial. Because our basic objection before.
Where is the
But
order of the trial court?
But the point for order of the trial court, please, sir. 72 is the order of the trial court.
When it was passed?
Yes. 27/1/2025.
Since 2025, you are restrained.
Yes, my lord.
We are issuing notice. Heard, Mr. Hayes.
If I may submit, my lord, we need a stay of the order of the lord.
No stay.
Or immediately we prefer the appeal within 90 days, my lord. 90 days we filed the appeal, my lord, the hearing took place on several occasions.
What is the urgency?
Urgency, my lord,
You
we
have
been restrained
waited. You have waited for 1 year.
My lord, we have been
You
waiting.
can wait till the period of notice.
My lord, we did not wait without doing anything, my lord. We filed an appeal before the learned first appellate court. If I may take your lordship to the appellate court judgment, my lord, several hearings took place in between.
2 court's orders are in favor of.
But Dalpat Kumar judgment is very clear, my lord.
Yes,
If there is a perversity.
We will decide that, but not at their back.
But unless and until your lordship stay the order, my lord, there is
What will happen if
my lord,
I
there is
don't?
my lord, we have been restrained to go to visit the temple, my lord, the community.
But you are restrained
seven
since 1 year you are not going to that temple. What is the urgency that immediately you have to go?
Well, urgency on faith, my lord. This is about the faith. If I may take your lordship to the picture, photograph.
No, the contentions will be decided.
Well, it will be decided unless and until, my lord, if your lordship permit me to show the, my lord, judgment passed by the learned first appellate
You have
court.
to satisfy that this is a fit case where notice should be waived.
My lord, this is a fit case
Urgency
where
is such.
not only notice, my lord, your lordship may grant the stay, my lord, because, my lord, if I may take your lordship to the first appellate court judgment, the perversity, my lord, 227, your lordship has the power to interfere with the judgment passed by any court, my lord. When the judgment is passed, my lord, de-hoarding, my lord, the principles, laid down principles. My lord, here the right title interest has been, my lord, prayed for on a government land. Your lordship is aware, in the government land, right title interest cannot be, my lord, prayed for. When the basic case of the petitioner or the plaintiff is not maintainable, whether, my lord, injunction can be granted. The cotton judgment, my lord, your lordship is aware. When the main prayer of the plaintiff cannot be allowed, whether temporary injunction can be granted at all. My lord, this is the basic question, my lord, which is to be decided by this honorable court.
We are fixing short date. Heard Mr. S. Vishwas, learned counsel for the petitioners. How many petitioners are there?
But there are more than 20, my lord.
Petitioners. This application under Article 227 of the Constitution of India has been filed by the petitioners, impugning the order dated 30/3/2026, passed by the Court of Civil Justice Senior Division, Dorong, in Miss Appeal number 2/2025, whereby the First Appellate Court affirmed the order dated 27/1/2025, passed by the Court of London, Civil Judge, Junior Division, number 1 Durham, in Miss J case number 134/2024, and dismiss the appeal filed by the present petitioners. Issue notice to the respondents. The petitioners issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode. Immediately after your usual mode, within 7 days from the date of this order, returnable on.
Till then, we may be allowed to at least visit the temple. It's a community temple for worshipping, nothing else. We have no residence there.
24th of July. The prayer for grant of interim relief shall be considered only after due service of notice on the respondent list accordingly.
Till then, it's all we have no residence there, my lord. The community wants to go and visit the temple for worshipping, my lord.
Let notice be served.
My lord, the last paragraph of the judgment just now I placed before this honorable court, my lord. This honorable court has held, my lord, when the, my lord, suit itself should have been dismissed at the threshold. My lord, continuing with the trial, my lord, paragraph 14.
No, we'll consider everything.
But till then, my lord, till the next date, my lord, we may be allowed to go and visit the temple at least for worshipping, nothing else. My lord, it will not hamper the case of the plaintiff, my lord. My lord, in fact, the plaintiff doesn't have any case, my lord. Your relative is aware. The government land, my lord, right title interest cannot be, my lord, paid for.
I have already dictated order.
Well, your lordship just, my lord, just see the, my lord, photograph of the temple, my lord. Your lordship may change the decision in the meantime, my lord.
On the next day, I will see those photos.
1 month, my lord, in between, my lord.
You have waited for 1 year,
No, my
you
lord.
can wait
We have been
for.
trying our luck in the first appellate court, my lord, by filing various petitions, my lord.
You have waited for more than 1 year. 1 month will not do any harm.
For only worshipping, my lord, nothing else.
Wait for 1 month.
At the outset, I am appealing for respondent IOCL notice. In this case, we are led by Learned Senior Counsel MK Sobri. He is unlike in another court. So let the senior friend start his argument. In the meantime, Learned Senior.
Or let him come. We'll take it next item.
No problem. No problem.
Because
otherwise, I can apprise the honorable court only about
basic
the
facts.
Basic facts.
Okay, facts you can say.
Yes.
Otherwise, there is an indication on the last date itself.
Yes.
That this will be contested.
That, my lord, we have withdrawn that, the writ petition. And for that purpose, we have already filed an affidavit also, and that must be in the record.
Okay, what are the facts?
Yes. My lord, prior to issuance of the notice under section 4 and 5 of the Public Premises Unauthorized Occupation Act, my lord, I apprehending the forceful eviction, my lord, had filed title suit number 10/1995. There are two stories, my lord. One is related to section 4 and 5 of the Unauthorized Public Premises Unauthorized Occupation Act, and the other is a suit, my lord, which I filed against the IOC. My lord.
Yes.
My lord, when I apprehended forceful eviction, my lord, then I had filed title suit number 10/1995. My lord, that suit was decreed. And it was decreed on the basis of adverse position.
In your favor.
In my favor.
You are the plaintiff.
I was the plaintiff over there, my lord. And the Union of India, along with the others, were the defendant. That suit, my lord, was decreed on 30/10/2006. Thereafter, my lord, the Union of India filed an appeal, being title appeal number 5/2026.
Yes.
And there, my lord, the judgment was pronounced. Until then, what the law was, my lord, that a plaintiff cannot seek adverse position against the real owner. So on the basis of that, the appeal was allowed and the decree was set aside.
Okay.
Thereafter, my lord, I filed one RSA, number 90/2007, my lord. That was also dismissed because till then that the case of Gurdwara Sahib was prevailing, my lord. 2019 8 SCC till then was not in force or not in picture.
Okay.
Now I will request my lord to peruse page number 146. The observation which was made while dismissing my RSA.
146.
146, it starts from 146, my lord.
Yes.
So, my lord, if I can take your lordship to page number 146, it is the order dated 9/2/2017, though my RSA was dismissed, but there was an observation made by the appellate court, first appellate, this honorable court, my lord. And that observation, your lordship will be pleased to see at page number 146 B and C.
146
B.
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 Yes.
We don't have any 146B.
146 as in a 9. Annexure 7. 82.
Yes.
My lord, while dismissing my RSA, this observation was made, my lord. I am taking your lordship to 146B, last paragraph, and a little of the second page.
Para 8.
Para 7, my lord. 7 and 8.
8 to 7.
Para
Yes.
8.
Yes.
Having heard the learned counsel for the parties and in view of the law laid down by the Supreme Court in the case of Gurdwara Sahib Supra, I am of the view that the appellant plaintiff suit could not have been decreed declaring his right, title and interest over the shoot land merely on the plea of adverse possession. As such, the substantial question of law framed by this court do not arise for decision in this appeal. Accordingly, it is held that there is no merit in the second appeal and the same is hereby dismissed. Thereafter, the four lines are most important, my lord, of that page number 146C. However, the protection granted by the learned first appellate court in favor of the plaintiff public appellant shall continue until such time he is evicted from the land by following the due process of law. This was the observation.
What protection was granted by the first appellate court?
That I was in possession of the land, my lord. I was in possession of the land.
No. What was the protection granted by the first? This is the observation in the second appeal.
Yes.
First appellate court granted some protection to it.
Yes. my
What
lord.
was that protection?
That protection was that I should not be evicted without taking due process of law. That is there at page number 143, my lord. 146. 143, my lord. My lord, here the 144 third paragraph, very small paragraphs, my lord.
Yes.
The appeal is alleged on contest. The appeal is alleged on contest.
Then it should have been allowed.
Yes. And the protection which was given is the protection of possession, my lord.
Now, where is the protection?
My lord, may I read, my lord? As the plaintiff is in possession of the shoot land, and that being the position, the plaintiff is to continue
Okay,
his
okay.
position.
This was affirmed by the second appellate judgment.
Yes.
That unless you are evicted by due process of
Due process of law. my lord.
Okay.
Yes.
Thereafter,
My lord, we filed one SLP also, and that was rejected. Thereafter, my lord, a notice came on 14/12/2020. That is at page number 152, 153, my lord. So this notice, my lord, was issued from the office of the state officer. State officer, and it reads like this, my lord. Petitioner so-and-so, opposite party so-and-so, notice under subsection 1 and clause B2 of subsection 2 of section 4 of the Public Premises Eviction of Unauthorized Occupants Act 1971. 2, I was the addressee, my lord. Whereas I, the undersigned, am of the opinion on the grounds specified below that you are in unauthorized occupation of the public premises mentioned in the schedule below, and that you should be evicted from the said premises. Grounds, my lord, is that the land described in the schedule hereunder is being occupied by you without any authority from the management of Indian Oil Corporation Limited, Assam Oil Division Limited, Big Boy. Now, therefore, in pursuance of subsection 1 of section 4 of the Act, I hereby call upon you to show cause on or before 29/12/2020 at 10 a.m. why such an order of eviction should not be made. And in pursuance of clause number B2 of subsection 2 of section 4, I also call upon you to appear before me in person or through a duly authorized representative capable to answer all material questions connected with the matter along with the evidence which you intend to produce in support of the cause shown on 29/12/2020 at 10 a.m. in the court of the state officer, Indian Oil Corporation Limited, Dubai, for personal hearing. In case you fail to appear on the said date and time, the case will be decided ex parte. Schedule, my lord, is given. The premises comprised of land measuring 2 bighas, 0 kattha, 0 lessa, equivalent to so-and-so, covered by dag number 605 and 606 of periodic patta number 1, situated near Muliabadi Shiv Mandir, Muliabadi Digboi, Moja Makum district in Sukia. So this letter, my lord, or this notice is dated 14/12/2020.
Yes.
My lord, that notice being defective was challenged before the Honorable Gauhati High Court in, my lord, WPC number 84/2021. And I would request the Honorable Court to, my lord, kindly peruse page number 154. Next page, 154.
Yes.
Here the name of the parties are there, my lord. And 155, the operative part of the order dated 12/1/2021. Heard Mr. H. Buragwai, learned counsel for the petitioner, also heard Mr. S. N. Sharma, learned senior counsel for the respondent, Oil India Limited. A notice under section 4.1 and 4.2 of the Public Premises Eviction of Unauthorized Occupants Act, for short Act of 1971, dated 14/12/2020, is assailed in this writ petition. Although some other grounds had been taken by the writ petitioner, Mr. S. N. Sharma, learned counsel for the respondent Oil, fairly states that there is a specific statutory form under the Act itself under which a notice under section 4 is required to be issued, and the present notice is admittedly not as per the specified form. Accordingly, the respondent IOC desires to withdraw the impugned notice dated 14/12/2020 with liberty to issue notice in the appropriate form as may be advised. In view of such a statement, the notice dated 14/12/2020 under section 4 of the Act of 1971 is declared to be inoperative by granting the liberty to the respondent IOC to issue a notice under appropriate form. Writ petition stand disposed of in these terms. Thereafter, my lord, when the first notice was discarded, thereafter on 24/3/2021, If your lordship pleases to peruse page number 102 and 152, 102, my lord.
102.
102, it is also reflected at page number 152, my lord.
157 plus 157.
157.
157.
Yes.
157.
So this show cause notice is dated 24/3/2021, my lord. It is in Form A. When this notice was served upon me, my lord, immediately I filed a petition that is reflected as page number 98 and 99. I was asked to appear on 5/4/2021. On that very date, my lord, I appeared. And if your lordship pleases to peruse page number 98 and 99, my lord. May I read that?
Yes, what you did.
Yes, my lord, I would take your lordship to this page number 99, paragraph number 3.
Yes.
Yeah. That the opposite party begs to state that upon perusal of the show cause notice dated 24/3/2021, he was shocked and amazed as to how the IOCL authorities have proceeded in the matter under the Public Premises Eviction of Unauthorized Act 1971 without approaching the competent civil court for adjudication of the case in hand. My lord, here what I have referred is the judgment of Honorable Justice Suman Sam, whereby I got the protection, and that is reflected at page number 146, my lord, which I have already shown to your lordship. In the matter under the Public Premises Eviction of so-and-so, without approaching the competent civil court for adjudication of the case in hand. Upon perusal of the show cause notice, it transpires that the issuing authority and the adjudicating authority are one and the same person. Furthermore, the show cause notice does not contain any documents like the petition, records, orders, documents, etc. pertaining to the claim of the issuing authority, that is the state officer, Indian Oil Corporation, Assam.
No, but why they have to go to again civil court when your plaint was dismissed?
My prayer was dismissed, but a protection was given that if at all I am to be evicted, my lord, I must be evicted by taking recourse to due process of law.
Yes.
And my lord, the due process of law is that if I am an illegal occupant, a decree can be obtained by them, my lord.
But
and that
illegal occupant in a public premise can also be.
My lord, illegal occupancy, they shall have to prove that my occupation is illegal. Why they did not go, my lord, to file the civil suit? Because of the reason of limitation. Because I am there since the year 1976, admitted fact.
Okay. Yes.
Though the trial court, my lord, and the appellate court gave me the protection that I should not be evicted without taking due process of law, the only remedy in the hands of the IOC was, my lord, to file a civil suit, prove their case, and then to evict me. But instead of doing that, they have issued this notice. Furthermore, my lord, when the particulars was sought for by this application, my lord.
Yes.
My lord, in that application, I have further, my lord, mentioned that the opposite party begs to state that the immediately thereafter consulted his lawyer in Gauhati and accordingly decided to SL the show cause notice dated 24/3/2021 before the Honorable Gauhati High Court. As a result, soon thereafter filed a writ petition challenging the legality and validity of the above mentioned show cause notice dated so and so. The writ petition was filed on such and such before the Honorable Gauhati High Court on various grounds, inter alia, praying therein for setting aside and questioning the show cause notice dated so and so. The opposite party is annexing herewith. So, my lord, that writ petition was withdrawn yesterday, my lord.
Okay.
Thereafter, my lord, annexing
No,
two
you
things.
file again a writ petition.
My lord.
You filed a writ petition for the second time.
Second time, correct.
Second time, yes, my lord.
What was the number?
It was, my lord, at acknowledgement is there at page number 101. Date of
First
filing
one
was
was
33/21, WPC number 3999 2021.
no, how it can be?
No,
No, no, it is in the acknowledgement, my lord.
no, I don't sir. My writ petition number 2648
2648
of 2021.
and earlier one was 84 of?
84 of 2021, my lord.
Okay.
Of 2648 খন স্যার আমি withdraw কৰিলো because আমাৰ court allow কৰিলে appeal to the section and 5 কৰিলো.
This writ petition you challenge the second
Yes.
notice under Public Premises Act.
That is there, my lord. Yes.
Okay. What happened then?
Court directed us to file an appeal because by then ex parte order was passed.
My lord, when that writ petition was filed, the court directed us to file an appeal under section 9
Because
of the
Public Premises.
Yes,
and because the ex parte order was already passed.
and we filed the appeal also, my lord.
Order to DS page 171, sir. Court order to that. It court 171 order process.
Okay.
My lord, if I can take your lordship to page number 171, what was the order passed in the second writ petition? That will be reflected, my lord.
171.
May I read, my lord, there?
One
Page 171, yes.
Yes.
It is the order dated 14/7/2021, my lord. Heard Mr. Raj Buragwani, learned counsel for the petitioner, also heard Mr. Asin Sharma, learned senior counsel assisted by Mr. M. Hussain. Learned counsel appeared on behalf of respondent number 225. Mr. Buragwani fairly submits that on the earlier occasion, that is on 9/4/2021, a copy of the order passed under section 5 of the Public Premises Eviction of Unauthorized Occupants Act 1971 was submitted before this court. Whereafter, the learned counsel for the petitioner sought time in order to prefer an appeal under section 9 of the said Act 1971. Today, it is submitted by Mr. Buragwani that an appeal was filed in the court of learned district judge, Tinsukia, whereafter, on its admission, the order passed under section 5 of the said Act 1971 on 5/4/2021 was stayed while order dated 17/4/2021 passed by the learned district judge Tinsukia. A copy of the order dated 17/4/2021 is put on record. As the petitioner approached the proper forum under such circumstances, I am of the considered opinion that this writ petition can be closed at this stage, which I accordingly do. The writ petition stands accordingly disposed of.
Okay. Thereafter?
So thereafter, my lord, that miss appeal number 2 of 2021 was filed. It is reflected, my lord, at page number
63.
159.
63 and express appeal to.
It's a memo of appeal.
Memo.
Memo of appeal, my lord, is at
Page 63.
page 63.
63.
Okay.
This is the memo of appeal, my lord, and whereupon the order was passed on 3/6/2026, that is the impugned order. The lordship will be pleased to see at page number 172.
Page number?
172 to 210.
This order you are impugning in this appeal?
Yes, my lord. Yes, my lord.
In this revision petition? Yes. Yes.
My lord, here various issues were framed, which your lordship will be pleased to see as page number 190. and thereafter the reason and decision was given, my lord. Whether there is any cause of action for the suit for the proceeding. I think. 190, page 190, my lord.
Yes,
Yes. Whether there is, accordingly, this appeal is now taken up for consideration. That from the grounds espoused in support of the instant appeal, the following issues emerge for consideration of this court. Whether there is any cause of action for the proceeding, whether the notice issued by the respondent under section 4(1) of the Act has been validly done, whether the appellant has perfected his title by way of adverse position, whereby the respondent IOCL has lost its right to initiate proceeding under the Act, whether the IOCL has been able to prove that it is the owner of the scheduled land, whether the proceeding initiated by the IOCL was bought by time, whether the impugned order dated 5/4/2021 is perverse and bad in law, whether the respondent IOCL did not follow the due process of law as well as the rules and procedures as provided under the Act, rendering the entire procedure illegal and liable to be set aside and interfered with by this court in appeal. To what other relief this was? Thereafter, my lord, the issue-wise decision is given, and that I am there since the year 1976. Your Lordship will be pleased to find at page number 192, fifth line, my lord.
That was your contention.
That was my contention, my lord. That was my contention, not here in the memo of appeal itself, but it was my contention in title suit number 10/1995 also, my lord.
Okay.
So, my lord, this is an admitted position that I am there since the year 1976 or 1974. It is an admitted position. That is one of the reasons why the trial court of title suit number 10/1995, my lord, decreed my suit, my lord. But in the appeal, it was dismissed because of the ground that till then, the defendant, apart from the defendant, plaintiff had no right to file any suit for adverse position. Only after 2019, my lord, that position came in from the case of, my lord, that KK Parmanji versus Union of India, and my lord, Ravinder Kaur Garewal versus Manjeet Kaur. So, my lord, if at all the IOC claims that the plot of land is there, they shall have to take due process of law to evict me, my lord. And in that regard, my lord, I would like to submit a judgment before your lordship. That is, citation to 2019-20 Supreme Court cases 705. Equivalent to 2019 SCC online, Supreme Court 394.
Which para you are?
Yes, my lord, first I would like to take the lordship to the head note or directly to paragraph number 49, 50 and 52, my lord.
What it says?
It is held, my lord, here. My lord, may I take the lordship to the head note a little?
Yes, yes.
Yeah. Government grants, largesses, public property and public premises. Public premises, eviction of unauthorized occupants Act 1971, section 4 and 5. Summary remedy for eviction cannot be invoked by government when occupant raises bona fide claim about his right over the premises. state officer will have no jurisdiction to issue notice under Section 4 of the Act of 1971. Proper remedy would be institution of suit for adjudication of dispute regarding ownership right
No, but
over
in
the
the
premise.
instant case,
My lord,
there is a judicial verdict that you don't have right.
there is a judicial verdict, my lord.
That you don't have right over these.
As of date, my lord, as of date, there is no such verdict that I am not the owner of the land.
No, but
Because protection was given to us.
the second appeal judgment of this court
Yes.
as well as SLP, which you preferred.
So the operative part of that appeal, my lord, is that a due process of law must
So
be
the
taken.
question involved in this revision petition is what would be that due process?
Yes.
Whether a notice under Public Premises Act is sufficient or whether a suit has to be filed.
My lord,
Already said, paragraph number 14 and point 5.
excellent, excellent. My lord, what is due process? That is well explained in this judgment itself, my lord.
Paragraph 49 starts.
Para?
Para 49, my lord.
Yes. Yes, please read.
At this stage, we consider a proceed to take note of the Constitution Bench decision of this court, wherein this court, after examining and upholding the constitutional validity of the PP Act in Kaisar-e-Hind Private Limited versus National Textile Corporation, Maharashtra North Limited, so and so, reiterated the view taken by this court in an earlier decision of Northern India Caterers Private Limited versus State of Punjab, that the PP Act does not create any new right of eviction, but only creates a remedy for a right which already exists under the general law. In other words, it was held that it only provides a remedy which is speedier than the remedy of a suit under the general law. This is distinguished, my lord, that if someone is going for the filing the suit, it will take time. Otherwise, if it is a summary process, it will be speedier in nature. Thereafter, my lord, keeping in view the statement of law laid down by this court in cited decisions, supra, when we examine the facts of the case in hand, we have no hesitation in holding that the appellants have raised a bona fide dispute on the question of ownership of the suit property, who are respondent number 1, Union of India. My lord, 5.1, 51, my lord, 51, 51.1, these are the 5 points which are very crucial, my lord. A fortiori, in such case, respondent number 2 has no jurisdiction to invoke the powers under Section 4 of the PP Act by resorting to a summary procedure prescribed in the PP Act, by sending a notice under Section 4 of the PP Act for the appellant's eviction from the suit property. This we say for the following 6 reasons. The reasons are, my lord, assigned. First, the facts set out above and the documents filed in their support in no uncertain terms establish that there exists a bona fide long-standing dispute as to who is the owner of the property, the appellants or respondents number 1, Union of India. Second, my lord, respondent number 1 itself admitted that there exists a bona fide dispute between the appellants and respondent number 1, Union of India, over the suit property involving disputed question of fact. See para so and so, so and so, so and so, the review petition filed by the so and so. Then third, my lord. Third, respondent number 1, Union of India itself stated in this court in earlier round of litigation while disposing of their civil appeals, number so and so, so and so, so and so of 1980, that they would seek disposition of the appellant from the property in question in accordance with law, and if need be, by filing civil suit in the civil court. The respondent cannot now be permitted to go back from their statement and take recourse to a remedy of summary procedure under the PP Act, which is otherwise not available to them. Fourth, this court, while granting a special leave to appeal on 3/8/2009, had also granted liberty to respondent number 1, Union of India, to file civil suit against the appellants if they are so advised. It was, however, not resorted to. Thereafter, my lord, I would like to take your lordship to 51.6.
Very important.
51.6. Sixth, the civil court alone could try and decide the question of declaration of ownership of any immovable property between the parties, and such dispute could not be decided in summary proceeding under the PP Act. This takes us to examine another question raised by the respondent as to whether judgment rendered by the Bombay High Court dated so and so stood merged in the order of this court dated 4/8/1998. In our view, it does not merge. In our view, the principle of merger is fairly well settled. For merger to operate, the superior court must go into the merits of the issues decided by the subordinate court and records finding one way or the other on its merits. If this is not done by the superior court, a plea of merger has no application in such a case. Thereafter, my lord, the other things have been discussed. So, my lord, here my respectful submission before your lordship is that in the first appellate stage, when the appellate court has hold that I can be evicted, there is no bar to that, but with the due process of law. In my respectful submission before your lordship, had there been any litigation filed by, or had there been any suit filed by the IOCL or all the 5 respondents, my lord, together, then I am having a plea of adverse position because I am there since the year 1976.
So your submission is that due process of law as indicated by the second appeal by this court is filing of a suit.
Correct.
Yes.
Yes.
Yes, Mr. Chaudhary.
Which is also mandate according to the Honorable Supreme Court.
If my learned friend has completed, my lord,
I have completed.
Now, my lord, the petitioner's case is that, my lord, he has been in possession of this particular plot of land, which is a very valuable land, my lord, since 1976. That is his case. But my lord, the finding of the in the title appeal, if your lordship will come, the judgment starts at page 128 and the findings at 140.
Yes.
May I read, my lord, the second paragraph at page 140. Now, in the instant suit, the plaintiff nowhere in the plaint nor in his affidavit evidence stated that his possession is hostile to the knowledge of the true owner. Admittedly, the defendant IOCL is the recorded owner of the suit land by the Exhibit D. That being the position, the alleged possession maintained by the plaintiff does not come under the ambit of hostile possession, or he acquired adverse title over the suit land. Any length of possession without knowledge and hostile to the true owner does not constitute adverse possession, and the person cannot be said to be acquired adverse title thereto. The learned counsel for the respondent virtually admitted this position of law during his argument, but contended that the plaintiff cannot be thrown out forcibly from the suit land until he is evicted therefrom in due process of law. Now, my lord, this paragraph, my lord, confirms the fact that, my lord, the adverse possession claim, my lord, that has been negated by the, my lord, first appellate court, which has been affirmed by the second appeal, which has been affirmed by the, my lord, Supreme Court. My lord, a review application was also filed before the Supreme Court. That has also been, my lord, rejected. Therefore, my lord, the only question that comes, my lord, whether the procedure under the Public Premises Act is the due process of law or not, my lord. That is, I think, my lord, that will be the precise question your lordship needs to answer.
Yes.
Now, my lord, your lordship will find this finding of the first appellate court that, my lord, he is an encroacher. He doesn't have any right. He has not acquired prescriptive title over the land.
These are based on the evidence laid in the trial court. So the elaborate evidence was, my lord, adduced by the plaintiff as well as the, my lord, Indian Oil Corporation, and on that basis, this finding is there. If, my lord, the argument of my learned friend is to be, my lord, accepted, that the Public Premises Act procedure is not the, my lord, due process of law, that means, my lord, we have to go for the same evidence again. Evidence has been laid. On the basis of that, my lord, the judicial decision has been there that he is a trespasser, he doesn't have any right, except that he cannot be evicted without due process of law. Now, whether this is a due process of law or not, my lord, this was also urged before the, my lord, the learned district judge. And your lordship will kindly see the findings of the learned district judge. My lord, judgment of the district judge, my lord, starts at page 172. The two issues are, my lord, important. If your lordship kindly comes to page 196. If, my lord, a procedure which is, my lord, process which is going on for the last 50 years, according to him in possession, my lord, no one can be evicted from land, government land, my lord, if it is occupied by an individual. Page 196, your lordship will find the findings, my lord. And it is a very elaborate order. Page 196, my lord, issue number 3. Has your lordship got it, my lord?
Yes.
Issue number 3, whether the appellant has perfected his title by way of adverse possession, whereby the respondent IOCL has lost its right to initiate proceeding under the Act. Issue number 4, whether the IOCL has been able to prove that it is the owner of the scheduled land. As both these issues are interconnected, this court takes up both the issues together for adjudication. In this respect, what comes to the mind of this court is that is the settled legal position that when a plea of adverse possession is projected, it is inherent in the nature of it that someone else is the owner of the property. In this regard, the court finds the acceptable pleading and proof from the appellant as to whose land the scheduled property is. Considering the fact that the appellant and the plaintiff himself had initiated title suit number 10 of 1995 in the court of the learned Munsif Tinsukia seeking declaration of ownership by adverse possession and permanent injunction restraining the defendant from interfering with the peaceful possession of the plaintiff over the suit land. It was the appellant's claim that he had perfected the title over the suit land by adverse possession as he was in exclusive, continuous and unchallenged possession of the land since 1976. That is his contention. From the said instance, it is incumbent and clear that the appellant had recognized the respondent as IOCL as the owner of the land. However, the settled legal position as laid down in the case of Karnataka Board of Wakaf, which was approved and affirmed in case of Narasamma, to constitute such adverse possession, the three classic requirements of adequate publicity, adequate continuity, and adverse to competitor in denial of title to his own knowledge have to be present. In order to establish adverse possession, as inquiry is to be made into the starting point of such adverse possession, and thus when the recorded owner got dispossessed would be crucial. The possession has to be in public and to the knowledge of the true owner of as adverse. And this is necessary as the plea of adverse possession seeks to defeat the right of the true owner. Thus, the law would not be readily accepting such a case unless a clear and cogent basis has been made out. Therefore, it has to be specifically pleaded and proved when the possession has become adverse in order to be real owner. Now, my lord, some case laws have been discussed. My lord, I will skip that because, my lord, Supreme Court decisions have been, my lord, relied on. And finally, my lord, at page 200, the finding is there. Because, my lord, if I read the case law, the ratios, my lord, it will take a long time. But my lord, the learned district judge has taken all the pain and referred to these cases and came to this finding. Last but one paragraph. Last paragraph of the, my lord, issue number
No, this
3 and 4.
finding is
Therefore, the
this
process
finding
under
is
my lord.
this finding is under challenge in this.
My lord. No, what I say is, my learned friend has said that, my lord, it is not the due process. That is what his argument is, and on that, my lord, he has, my lord, placed a decision of Supreme Court, my lord. My lord, your lordship is aware of the, my lord, the principle that, my lord, the ratio of any case has to be understood on the background of that case. My lord, to support that, my lord, I'll place one decision.
Yes.
Why, my lord, I say this? Because the case here is that already evidence has been laid where there is a judicial finding that you are a trespasser. So, my lord, another process of a suit means the, my lord, leading the same evidence again. Those are not the facts in that case. If I may place this case law,
No, no.
my lord, AR
He preferred a suit
my lord.
claiming his title on
Yes.
the basis of adverse possession. Court held that that is not the law. His title cannot be perfected on the basis of adverse possession till that because till that period the law was not declared by the apex court.
Right.
Now the law is different.
True, my lord.
But therefore his suit was dismissed. But does it mean that you need not to file any suit for his eviction and you can go for summary procedure? That is the question to be decided in this revision petition.
My lord,
And can it be decided today?
My lord, my submission before your lordship is that, my lord, if the law has changed, and my lord, that changes the finding of the.
No, he may not get benefit because he cannot come again for filing a suit, but he can.
He could have filed a review application in view of the change of the law. That he did
No,
not
no.
do.
Question is whether IOCL is required to go for summary procedure or go for a regular trial for evicting a person who is claiming to be in possession for last more than 50 years.
Not 50 years, my lord. There is a finding that his possession has been, my lord, declared to be from, my lord, 1985. Not as he has claimed that is a.
Say in 1985.
1995, that is the, my lord, he trespassed into the land on 2/4/1995. That is a finding of the, my lord, first appellate court.
Yes, that question is to be decided in this revision petition, that where the possession may be permissive, maybe he is a trespasser. If it is for a long period of time, can summary procedure under section 4 can.
My submission is that, my lord, so far as his right over the land is concerned, my lord, that has been decided by regular suit.
Yes.
That cannot be, my lord, decided once again, my lord. Because, my lord, if we file a suit, we have to adduce evidence again, which evidence has already been laid in the suit. He has to, my lord, lead evidence, which evidence has already been laid in the suit. And on the basis of those evidence, a finding has been recorded and, my lord, confirmed by the Honorable Supreme Court. And if your lordship, my lord, sees the order of the Supreme Court, my lord, because that has been not pointed out, my lord, even, my lord.
No, but that to decide that question, a long hearing would be required.
My lord, my submission is that, my lord, he doesn't have a prima facie case, my lord, for admission, because, my lord, your lordship has seen that a long trial has already taken place, my lord, from the suit was filed in 1998. And, my lord, in the Supreme Court, 1995, my lord, the suit was filed. And, my lord, the review application was dismissed by the Supreme Court, my lord, on 3/11/2020.
No, my query is the finding of the trial court, the finding of the district judge's court in Sukhya in the impugned judgment, though
That
it
is
is
a very recent decision,
though it is a long judgment, but ultimate finding is that the process adopted by IOCL can be regarded as a due process, as indicated by this court in the second appellate's judgment. Now that is to be correctness of that finding is to be ascertained.
I submission, my lord, I asked myself this question, my lord. Will the court eventually say, could, my lord?
We cannot say now without.
That, my lord, the procedure under the, my lord, The Public Premises Act is a not
May-
a due
because
procedure.
The
Because my lord,
petitioner has relied upon some judgments, whether these are applicable or not, it has to be seen.
my lord, initial submission will be that in those cases, my lord, there was no suit. Here was a suit. That's why I say that, my lord, the ratio.
But it is sued by the other,
themselves.
no, sued by the person whom you are seeking to evict.
And my lord, findings are there. on
But
the
there
basis
was
of
no
that.
suit from your side.
Findings are there on the basis of their, my lord, the evidence laid by him in his suit. And we
So
have also made it.
therefore, will this question is not required to be considered in this case, that whether a suit from your side is required or not.
My lord, the London district judge has given, my lord, the reasons. I did not read the, my lord, the Supreme Court cases that he has relied, my lord. If your lordship, my lord, reads that, then, my lord, the position will be clear, my lord. I wanted to cut short to save time. He has given reasons and referred to Supreme Court cases. If your lordship kindly comes through, my lord, his findings at page 196 again, my lord. He has relied on quite a number of, my lord, decisions of the Honorable Supreme Court. And the decision my learned friend is, my lord, relaying, that has not come up now, my lord.
So your submission is that this should not be admitted.
My submission will be, my lord, this will put a, my lord, premium on a person who is an encroacher and has been there since 1995 in the land, in the public.
1995 or 85?
1985, so 76.
Okay.
Then nobody can be evicted, my lord, if this type of, my lord, suit file and such a long period of time, my lord. This is a, my lord, in fact, he has evicted.
No, I am not giving finding that suit has to be filed. But that question is to be determined in this revision petition, whether suit has to be filed or not. And
I urge your lordship to, my lord, understand this question on the backdrop of the fact that, my lord, evidence had already been, my lord, adduced by both the parties, and the, my lord, case law relied on by my learned friend. That ratio will not be applicable in this case, and for that, my lord, I am relying on this decision, my lord. Two decisions. This is, my lord, Sudhanshu Sekhar, my lord, State of Odisha versus Sudhanshu Sekhar. That is a 1968 case, relevant paragraph will be paragraph 12. And, my lord, which has been reiterated and reaffirmed in 2002.
what it says?
It says that, my lord, the ratio of a case has to be understood on the backdrop of the facts of that particular.
Yes.
The ratio my learned friend is, my lord, relying on. Where, my lord, there was no suit, there was no evidence.
What my query is, I am not negating your submissions. Whether it requires a detailed hearing. And my view is that the contention raised is such that it requires detailed hearing.
In that event, my lord, your lordship will fix a short date, my lord, for hearing.
Yes, that can be done.
That is what I, after your lordship has, my lord, express your.
Because
lordship.
a finding has to be given as to whether the due process indicated in the second appellate's judgment has been followed by the IOCL.
But what I submit is that, my lord, that law he cannot rely on, because, my lord, that facts are completely different. There was no evidence at all. Here, my lord, elaborate evidence was there, which has been affirmed by the Honorable Supreme Court. That he is a trespasser, that he doesn't have the protection of adverse position. These findings are already there, my lord.
Okay.
So what purpose would a suit, my lord, serve? The same findings, my lord, the same evidence that has to be laid again. And the court, even if, my lord, we file a suit, the trial court or the
No, I am not saying that filing of suit is necessary, but to find out whether you have to file a suit or not, this court has to decide the issue before it. and which will require a long hearing. Heard Mr. A. Sattar, learned counsel for the petitioner. Also heard Mr. M. K. Chaudhary, learned senior counsel assisted by Mr. K. Kolita, learned counsel for the all the respondents.
My lord, he has pleaded, my lord, impleaded Pavitra Kumar Deuri as the respondent number 5. But I find that, my lord, there is no allegation of malafide. I don't know why he has been made a party by a officer.
Who is Mr. Fai?
Made a party.
Who is the state officer?
No, state officer has been made a party.
The state officer as a person, a state officer as a designator has made a party, and the person who issued the notice is also made a party.
But he has issued notice in his official capacity.
No.
No, state officer is not a party.
No, a state officer, why he is required to be made a? He is in, he has whatever notice he has issued, that has been done in his official capacity.
And they have not alleged any malafide.
You have not alleged any malafide.
We have, there's one aspect, my lord, if I may be allowed, my lord. We have said that the state officer who had issued the notice to us is the same person who is going to adjudicate upon the cause in the proceeding under section 5, and which he has done.
But for that also, he need not to be made a party.
Surprised that his name may be deleted.
As a person, he will be.
Yes.
As a person.
As a
In
person.
official capacity, he will be there.
Yes, madam.
Then we will receive notice for 1 to 4.
Though respondent number 5, that namely Mr. Pavitra Kumar Deuri, state officer under public premises, Eviction of Unauthorized Occupant Act 1971, come DGM within bracket admin and welfare, Indian Oil Corporation, or you can represent him, or he is made in his personal.
If they can show that they have alleged malafide, then he is a necessary
Okay.
party, otherwise not.
Has been made a party. However, it appears that no malafide has been alleged against him in person. Hence, under the facts and circumstances of this case, his impleadment in this case is not necessary. Accordingly, the name of respondent number 5 is directed to the struck out. In this appeal, the main contention of the petitioner is that though the petitioner had filed a suit claiming his right, title, and interest over where is the description, the right, title of and interest over the land involved, over the land in respect of which notice under section 4 of the public premises eviction of within bracket eviction of unauthorized occupants Act 1971 has been issued to him, and though the said suit last line to production. No, starting last line. No, issued to him on the basis of adverse possession. On the basis of adverse possession. He submits that though the said suit within bracket title suit number 10/1995 has been dismissed by the trial court mainly on the ground that a person cannot claim title on the basis of adverse possession.
My lord, that was decreed, my lord.
In my
Suit was decreed.
Suit was decreed, my lord.
The
TS 10/1995.
in appeal it was reversed.
Yes, my lord.
Though the suit was decreed on the basis of adverse possession of the
Yes, my
present petitioner on the suit land. However, on an appeal preferred by the present respondents, that is title appeal number 5/2026, the judgment of the trial court was set aside mainly on the ground that a person cannot perfect his title on the basis of adverse possession. The learned counsel for the petitioner further submits that against the judgment of the first appellate court, the present petitioner preferred a regular second appeal before this court, that is regular, which was registered as regular second appeal number 90/2007. He submits that though the aforesaid regular second appeal was also rejected was also dismissed by a coordinate bench of this court. However, while dismissing the regular second appeal, an observation was made that since the petitioner is found to be in possession over the land in respect of which possession over the suit land, he can be evicted therefrom only in accordance with due process of law. Learned counsel for the petitioner further submits that though the respondents thereafter have issued notice under Section 4 of the Public Premises Eviction of Unauthorized Occupants Act 1971 and in an appeal preferred against the issuance of such notice by the present petitioner under Section 9 of the said Act, the Court of Learned District Judge Tinsukia, by the impugn order, has observed that the process undertaken by the IOCL for the eviction of present petitioner in terms of the provisions of public eviction, this key act as
Public premises,
Public-
eviction of unauthorized occupants Act 1971.
Public Premises Eviction of Unauthorized Occupant Act 1971. cannot be stated to be without due process of law, comma, however, he submits that in view of the laid down law by the apex court in the case of Kai Khos CH KAIKHOSROU within bracket Chick Kawas G from G versus Union of India and others reported in 2019-20 SCC 705. The under under the facts and circumstances of involved in this case, a civil court alone could try and decide the question involved, disputed questions involved between the parties in this case. Hence, he submits that the appropriate due process as indicated by the ordinate bench of this court in the judgment of the second appeal, that is RSA 90/2007, would be filing of a suit by IOCL. Stop. On the other hand, Mr. M.K. Chaudhary, the learned senior counsel for the respondent, submits that the first appellate court, that is the court, first appellate court in the title appeal number 5/2026 has given category.
15, my lord. 15.
Title appeal number
15 of 2006, my lord. Title appeal 15.
Title appeal number 15 of
2006, my lord.
2006
Yes.
has given categorical finding that the possession of the present petitioner over the suit land was not adverse to the real owner, that is IOCL.
Finding is that he trespassed into the suit line on 2/4/1995, and my lord.
And that the possession is also not adverse. And further, a finding was also given that though the petitioners are claiming and though the petitioner is claiming, there is only one petitioner.
Yes.
The petitioner is claiming exclusive, continuous, and unchallenged possession over the suit land since 1976. It was only from the year 1985 the petitioner was in the 1985 or 95.
My lord, the date has been given 2/4/1995. He trespassed into the land.
From 2/4/1995, he trespassed into the suit land. He submits that in view of the clear finding by the first appellate court regarding the fact of adverse possession against the present petitioner, the IOCL is not required to file a fresh suit. Otherwise, it may have to adduce same evidence. Hence, he submits that the appropriate due process as indicated by the by this court in RSA 990/2007 is by taking recourse to the provision of Public Premises Eviction of Unauthorized Occupant Act 19. What is the year?
71. 71, madam.
1971. And as such, he submits that the impugn order there is no infirmity in the impugn order, and he therefore prays for dismissing the present revision petition without admitting it. Stop. After considering the submissions made by learned counsel for both sides, as well as going through the materials available on record, this court is of considered opinion that one of the main issues which this court has to decide in this revision petition is as to whether the due process for eviction of the petitioner indicated in the judgment of this court in RSA number 90/2007 would be by filing a separate suit by the respondent, that is IOCL, or by taking recourse to the provisions of Public Premises within bracket Eviction of Unauthorized Occupant Act 1971. This court is of considered opinion that said question would require a full hearing, and as such, same cannot be disposed of at this stage of motion today. Accordingly, this revision petition is admitted for hearing. Since Mr. M.K. Chaudhary, the learned senior counsel, appearing for the respondent, has already appeared for the no. So what is her name? Since Mr. K. Kolita has already appeared for the respondents, no formal notice need to be issued to the respondent. Let this, whether records would be necessary.
Everything is there.
Yes.
Evidence there.
No, question is limited. What would be the due process?
Yes, my lord. Question is very limited. What is the due process? For eviction? There is no question in the record.
In Calica last line. Release this matter for final hearing on 8th of August. Till then, the
8th is Saturday. Let it be 11.
11th of August. 11th August. Till then, the impugn order shall remain stayed.
Impugn order dated 3/6/2026. 3/6/2000.
Impugn order dated 3/6/2026, passed by the Court of London, District Judge Sinsukia in Miss Appeal number
2/2021.
2/2021 shall remain stayed. List accordingly.
Order, item 26.
For already responded.
May I please your lordship? Service has been completed, lordship.
Because
Item number?
26, my lord.
Heard Miss, what is your name?
D. Sharma.
D. Sharma, Learned Counsel for the item number 26.
Yes, lordship.
You are appearing for
On behalf of D. Nath.
appearing on behalf of Mr. D. Nath, Learned Counsel for the appellant. Also heard Mr. H. Das, Learned Counsel for respondent number 1, as well as Mr.
Already responded.
You are appearing for all?
Yes.
Learned Counsel for all the respondents. Where is the file?
Lordship, interim is there, that may be continued.
In
The-
Bhutti court, they have already decided.
Record I say, record I say.
LCR received.
This appeal is, it appears from record that this appeal is ready for hearing. Hence, let this matter be listed for hearing
Date may be
15th of September.
Interim may be continued.
Till then,
Already
till
clear.
next date, the interim order, interim relief granted earlier shall continue.
27.
May it please your lordship. Lordship, in the review petition number 31 of 25, we have filed affidavit in compliance of service of notice to respondent number 2 through Dusty Mode. And along with it, we have also filed 3 IAs, your lordship. In the IA, we are praying for withdrawal of the FD in the name of affiliate number 1, 2, and 3. There are 3 total FDs, your lordship. Your lordship, the FDs are.
Why this review petition?
Sorry, your lordship.
Which order you are seeking to review? This review petition has been filed
Yes, my lord.
against which order? Heard, Mr. What is your name?
J. Hawk, your lordship.
J. Hawk, Learned Counsel for the review petitioner, who submits that the review petitioner has filed an affidavit in compliance of the service of notice upon respondent number 1, upon respondent number 2 through Dusty Mode.
2, your lordship, yes.
Who is respondent number 2?
The insurance company, your lordship. Cholamandala.
On whom you have served?
The officer of the insurance company, his name is K.K. Bhattacharya, your lord.
K.K. Bhatta is a lawyer, counsel. You have served the notice on.
Yes, your lordship.
Kiman item on the engaged counsel for the respondent number 2. Stop. Let the name of Mr. K.K. Bhatta be reflected in the cause list as engaged counsel for respondent number 2 in this case. And against 1, it appears that the notice issued to respondent number 1 has not yet returned. The petitioner shall take fresh steps for issuance of notice upon respondent number 1 by speed post within 7 days from the date of this order. Mr. Bhatta, you are appearing for?
I'm appearing for the respondent insurance company.
Okay. What, can you returnable on 12th of August.
And Lordship, we have also filed 3 IAs for withdrawal of the
Yes.
ICR.
And later on, Mr. K.K. Bhatta, learned counsel for the respondent number 1 appears. You have received the copy of review petitions. List accordingly. ISO. Regarding IA, you have it.
Regarding 3 I have received.
3 IAs.
Regarding review petition, what's it? I have not accepted.
Review petition you have not received. The Amita in review petition continue one more line. The petitioner is directed to furnish a copy of the review petition to Mr. K.K. Bhatta within 2 days of the date of this order. In IA, you have any objection?
Regarding fixed deposit on day 1 to withdraw the amount, I have nothing to say.
Which IA?
So Lordship, 3 IAs are there, IA 831, 836 and 1001 of 26.
Why 3 IAs?
There are total 3 respondents for the 3 lakhs fixed deposit for each applicant.
So separate IAs have been. This interlocutory application. Heard Mr.
J. Hawk.
J. Hawk, learned counsel for the petitioner. Also heard Mr. K.K. Bhatta, learned counsel for the respondent insurance company. This is in I number 831. Separate order. 831. This interlocutory application has been filed by the petitioner / claimant, praying for allowing the petitioner to withdraw the FDRs of rupees 3 lakhs, which is maintained in Assam Gramin Vikas Bank in the name of the present petitioner in terms of judgment dated 23/12/2019 passed by the Motor Accident Claims Tribunal in MEC case number 206/2017. Why you have preferred review?
Review petition, your lordship, I don't know the main reason, my senior would know.
The learned counsel for the insurance company does not have any objection against the prayer made in this interlocutory application. Considering the grounds stated in this interlocutory application, the prayer is allowed and the petitioner is allowed to withdraw the FDR of rupees 3 lakhs maintained in the Assam Gramin Vikas Bank in her name in terms of the judgment and order passed by the Motor Accident Claims Tribunal on 23/12/2019 in MEC case number 2006/2017. This interlocutory application is accordingly disposed of. In same line, other two also. Name of the amount will be different. And the other two interlocutory applications are also disposed of.
Yeah.
Listed.
Also, like,
May please adoption. Service upon respondent number 1 and 2 is already complete. Respondent number 3 to 6 are to appear today to the council. Some and Chaudhary was to appear.
So someone has been engaged.
Right, adoption.
Item number
28.
28. Heard, Mr. What is the name?
A.R. Pal.
A.
R. Pal.
A.R. Pal, learned counsel for the review petitioner. Also, Miss M. F. Ahmed, learned counsel for respondent number 1 and 2. On perusal of the office note dated 16/6/2026, it appears that service report in respect of notices issued to respondent number 3 to 6 are still awaited.
Lordship, I was informed that Mr. N. Chaudhary was appearing for respondent number 3 to 6.
Who informed you?
The other side itself. N. Chaudhary was. N. Chaudhary.
But there is nothing. So we'll wait, we'll give some time. I wait for the service report. Release this matter again on 12th August.
Same matter for item number 29.
Item number
29.
29.
Also same order. Same order, same date.
Same order.
Service complete, Lordship.
Heard Mr. B. Devri, learned counsel for the petitioner. Also heard Mr. A. Islam,
Respondent number 1 and 2.
learned counsel for respondent number 1 and 2, as well as Mr. V. K. Chishi, appearing for respondent number 3, 5, and 6. What happened to 4?
Orally notice served on Lordship Office Note dated 8/10/2025.
Okay. The service of notice on all respondents is complete. Hence, let this matter be listed for hearing on 15th of September. The interim order passed earlier shall continue till next day.
Due.
Please instruction. I appear for the respondent manner, whereas there is a limitation application. But my respective submission is that my lord, the limitation petition is not maintained. It's a application filed under Article 227.
Oh,
They have filed an application under limitation, like section 5. The petition is not maintainable, my lord. Moreover, my lord, in the last occasion, I asked for the copy of the.
227 CRP is not registered, not yet registered.
So because
Why?
they have filed this application under section 5.
No, my lord. Correct this application before it is registered. I have filed section 151 CPC, my lord.
The application, in this case.
Why this
CRP I have filed.
1183. 1183 is the
Limitation.
1183 is the limitation application.
No, is there any period of limitation for an application under 227? No.
Moreover, my lord, when I appeared in the limitation application,
CRP.
I pray for my lord, ask for the copy of the CRP, my lord. I found, my lord, the impugn order, which was impugned in the limitation as well in the CRP, my lord. That was not in the revision petition, my lord. The impugn order was not there in the revision petition. Can we see, my lord? They have impugned an order dated 14/12/2022. As per that order, my lord, they have filed this limitation application, my lord. On that basis, my lord.
Okay, we are directing for registration of the CRPIO. CRP, then you take your objection.
Here in the impugn order, my lord, they have impugned, my lord. That was not there.
No, we cannot consider CRP now because it has not yet been registered.
The limitation application is not met.
That we are disposing of today.
My lord, one more prayer, the petition number 3, my lord, this expired on the 11th of June 2026, my lord. But he has no legal hair.
No, first you let your CRP revision petition be registered. Then we will consider all matters. Heard, Miss, what is your name?
B. Devi, my lord.
B. Devi, learned in interlocutory application. B. Devi, learned counsel for the applicant. Also, Mr. Shiladitya, learned counsel for the respondents, who submits that this interlocutory application is not maintainable, as in case of application filed under Article 227 of the Constitution of India, no prescribed period of limitation has been, no period of limitation has been prescribed under any law. Stop. This court is in agreement with the submissions made by learned counsel for the respondents, and accordingly disposes of this interlocutory application with a direction to the registry to register the connected CRP, the connected civil division petition, and list the same for motion on
16th July.
On 16th of July. The The petitioner shall furnish a copy of revision petition to the
They have already furnished.
okay, revision 16th of July. List accordingly.
Obliged.
And last line, list accordingly cutting the 16th of July. Yes,
Well, in this case, delay of 52 days in filing the RSML. On last occasion, another coordinate bench directed to ascertain the exact address. We are not able to do that. 2 weeks time may be granted.
and Mr. R. Chakravarti, learned counsel for the
Otherwise, the address is the same, of the trial
applicant
court.
who seeks some more time for ascertaining the correct address of the sole respondent. The prayer is allowed. Let this matter be listed on 29th of July.
Item 33.
May it please your lordship. My lord, office noted that 17.6 would show that service is possibly not complete, my lord. But we took steps, my lord. The AD card has not returned.
Heard Mr. N.J. Das, learned counsel for the petitioner. Office note dated 17/6/2026 indicates that service report in respect of notices issued to respondent number 1 and 2 is still awaited. The registry is directed to place the postal track consignment report of the notices issued to the respondents through speed post before this court on the next date fixed. Let this matter be listed again.
Interim may continue, my lord.
17th of July.
The
The
clerk.
interim order shall continue the next day.
Obliged.
Item 34.
Not the office note dated 17/6 indicates, my lord, the AD card, not the unserved notice has returned, my lord. As regards the sole respondent. my lord.
Mr. S. Khaun, learned counsel for the petitioner. Office note dated 17/6/2026 shows that the service report in respect of notices issued to the sole respondent is awaited. The registry is directed to place the postal track consignment report of notice issued to the sole respondent by speed post before this court on the next date fixed. List on 17th of July.
Interim order may be extended.
The interim order shall continue till the
Much okay.
Item 25.
According to the notice, my lord, respondent's entire appearance, my lord. Service is completed, my lord, I think.
heard Mr.
N. Bora, my lord.
N. Bora, learned counsel for the petitioner, also Miss S.M. Kashyap, learned counsel for the respondent. Let this matter be listed for hearing, admission hearing on 12th of August.
Interim order may be continued.
The interim order shall continue.
March.
Item 26.
12.
It is also in the office note, neither AD has been received or
Heard Mr. What is the name?
yes, so yeah.
S. Vakil, learned counsel for the petitioner. Office note dated 17/6/2026 shows that the service report in respect of notice issued to the sole respondent is awaited. The registry is directed to place the postal track consignment report of notice sent to sole respondent by speed post on the next date fixed. Let this matter be listed. 20th of July.
Lordship had directed the registry to place the postal tracking report. I think he's appearing. Everybody. The postal tracking report shows that the service was delivered on 12/6/2026.
How many you are
On
appearing
a
for?
single respondent.
Respondent one, madam. State of Assam.
One, and you are
I'm for 2, 3, and 4.
For
2, 3, 4. And as regards 5,
private respondent, no one has filed Vakalatnama till now.
My lord, I had a look at the case. My lord, is totally private, my lord.
but you are made a party.
Yes, my lord, that private respondent is important. That is what I'm trying.
Okay. Private respondent is R5.
Lordship.
Okay. Heard, Mr. What is the name?
Amdas.
M. Das, learned counsel for the petitioner. Also heard Mr. K. Bhattacharya.
Respondent one.
K. Bhattacharya,
For respondent one.
appearing for respondent. Learned government advocate appearing for respondent number 1. Also heard Mr.
Escotu.
S.
Escotu on behalf of RM Das.
S. Koso.
Kotsu
Kotsu,
on behalf of RM Das.
appearing on behalf of RM Das, learned counsel for respondent number 2, 3, and 4. On perusal of the postal track consignment report of notice issued to respondent number 5, it appears that the notice sent to respondent number 5 by speed post was delivered to him on 12/6/2026. Stop. Hence, notice issued to the said respondent is held to be duly served. Let this matter be listed for admission hearing on 14th of August.
My lord,
Interim order to continue.
my lord just dictated, the case can go ahead if they do not appeal. That may not be the cause to go on delaying. Because the private party does not appear. That
No,
may not be the
we,
cause to go on delaying because my lord has already ordered.
Lordship has already fixed it on 14th of August. Let us wait till 14th of August. In the
we,
meantime,
we,
Lordship,
we have
to continue.
fixed it on 14th of August. If the other side appears, okay. Otherwise, it will proceed ex parte.
Yes, yes. That would be the best thing.
Lordship, the interim order to continue.
The interim order shall continue till next day.
Obliged, Lordship.
In this matter, Lordship, service upon respondent number 3 has been completed. They are appearing, but 2 perhaps waited, Lordship.
Lordship, 2 is a defective one, Lordship. It will never be completed. Lordship, who will represent the 2? They have given the workers' union, but someone will, may represent the workers' union. None is there. Who will represent? It's a defective, Lordship.
Yes.
They are the party in the Lordship labor court.
Who is to?
Who is the
Assam Spun Mills.
Silk Mills Workers Union?
No, but who will represent? To whom it will? A workers' union has to be represented by
Someone.
someone.
General Secretary is there, Lordship.
General Secretary is the respondent number 3. They have specifically completed General Secretary.
You will represent
I am
number.
representing General Secretary.
You may also represent number 2. Who is 1?
1 has a strike of Lordship.
One was the presiding officer.
You take instruction whether you can represent 1.
Someone, Lordship, this I may take, but it may be some executive member, president, or secretary. But
Is this a registered society? This worker
This is
union
trade union.
registered under trade
Yes,
union.
Trade union act.
Then you can the general secretary may appear. You
In fact, that is true that although they have committed a wrong, but it is not necessary to implicate the party just in the name of the trade union. Must be represented by someone. As I am representing the general secretary, I can also represent.
yes. You
And another thing is, Lordship, it is an CRPIO, but they have challenged the order passed by the labor court. The labor court is not a civil court. And only the civil court order passed by the civil court can be challenged under Article 2 to 7.
No,
When- when
that
the
we will
Congress is
decide.
there.
That we will decide later on.
Lord.
Let the service be complete. You may amend your cause title. In the meanwhile, let him take instruction that day.
If he appeared, then okay. If he not appeared, then I have to amend lordship.
No, otherwise also you have to amend. Somebody has to represent Assam's Spun Silk Mill Workers Union. President, Secretary, someone has to represent. Heard.
Zaman lordship.
Mr. M. Zaman, learned counsel for the petitioner. Also heard Mr.
F.Z. Mojumdar.
F.Z. Mazumdar, learned counsel appearing for respondent number 3, who has pointed out that though the Assam Spun Silk Mill Workers Union has been made respondent number 2 in this civil revision petition. However, it is not indicated as by whom the said union would be represented in this revision petition. On this, the learned counsel for the petitioner sought leave of this court to amend the cause title of the present revision petition, civil revision petition. The prayer is allowed. The petitioner may file the amended cause title on or before the next date. In the meanwhile, learned counsel for respondent number 2 is requested to take instruction as to whether he can represent respondent number 2 in this case. Let this matter be listed again. 3rd of August.
Lordship, interim order is there.
The interim order shall continue till next.
Obliged, your lordship.
Item 39.
That is a lot. Here I am appearing for all the respondent, my lord.
Yes. What is this?
The matter may come up for admission hearing, my lord, next week, my lord.
Not next week. It will go after vacation. Heard Mr. H.R.M.N. learned counsel for the petitioner. Also heard Mr. D.J. Haloy, learned counsel appearing for all the respondents. The appearance of parties in this case is complete. Hence, this matter will be listed for admission hearing on 5th of August.
My lord, last order, my lord, there is an observation in the last paragraph, my lord, can you see, my lord?
Yes. Okay. The case is fixed at argument stage.
Yes, yes, my lord.
When is the next date?
My lord, the next date is fixed on 28/7/2026.
Before 28/7 at the date. 23rd July.
Obliged, my lord.
Item 40.
May it please your lordship. Lordship, as per the office note 17/6/2026, service is completed. Respondent has filed their okalatnama. Matter may be listed for admission after the vacation, my lord.
Miss, what is your name?
D.N. Das, on behalf of D. Mohanta.
B.N. Das.
D.N. Das.
D.N. Das appearing on behalf of Mr. D. Mohanto. Also heard Mr. I. Bhattacharya appearing for all the respondents, sole respondent. Stop. Let this matter be listed for admission hearing on 14th of August.
Item 42.
If I may, my lord, the IA is for condonation of delay of 109 days in preferring the connected second appeal, my lord.
Service is complete.
Yes, ma'am.
You are appearing for,
I am for the respondent number 1 to 3, my lord. I may be allowed to keep some time to file written objection, okay?
but Mr. A. Iqbal,
G. Imtiaz, ma'am.
G. Imtiaz, learned counsel for the applicant. Also Mr. A.R. Talukdar,
Ayat Talukdar.
sorry, I.A. Talukdar, learned counsel for the respondent, who prays for some time for filing written objection against the prayer for condonation of delay. The prayer is allowed. Let this matter be listed. 12th of August.
Well, deeply obliged, ma'am.
May it please your lordship. Your lordship, my senior was about to argue in this matter, my lord. So due to some personal difficulty, she just left the court. So kindly if this matter can be listed on Monday, lordship. Appeal is yet to be admitted, my lord, in this matter.
What is this?
This is RSA.
No, IA for?
IA for condonation and amendment and stay. 3 IS.
Condonation notice has been issued. No, we are issuing notice. Heard Miss S. E. Murtaja, learned counsel for the applicant. This application under Section 5 of the Limitation Act has been filed for condoning the delay of 1412 days in filing the appeal has not been admitted. Appeal has already been admitted for filing the impleadment / substitution petition for substituting the legal heirs of respondent number 1 in the connected RSA number 52/2026 and IA number 1564/2026. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as the usual mode within 7 days from the date of this order, returnable on 12th of August.
Obliged.
Item 44.
May I be before you see? My lord, this petition, my lord, IA, we file, my lord, under certain circumstances, my lord. The execution court has already executed the judgment, ex parte judgment and decree. Now, now the problem is there are 3 scheduled in that decree, my lord, which has executed, my lord. 3 scheduled land.
3 schedule.
Yes, A, B, and C are the scheduled land.
Okay.
And out of 3 scheduled lands, all the 3 scheduled lands are in fact, my lord, is a ancestral property having common duct, arising out of common duct.
Okay.
All parties in the between the parties in the, my lord, in the suit are having common duct. Now the problem is, my lord, since execution has been carried out, and we are not affected by the schedule A and schedule C. So execution has been carried out.
Okay.
Now, but schedule B land is concerned, tag number 45. That schedule, in that schedule, your lordship, the documents I have annexed, the plaintiff were nowhere recorded. Their names were nowhere recorded in the official record. So at this stage, if because of execution wrongly or rightly, because of the execution proceeding, if the nature of the suit, execution, nature of the schedule land is, if it is changed, then ultimately, my lord, your lordship will be deprived of.
CRP, sir. In the CRP, wow, which order you are impugning?
Now, CRP, we are not, in the CRP, we only problem is we ex parte, since ex parte proceeding has been drawn, we file a order 13 rule, order 9 rule 13 vacating the ex parte judgment and decree. That has been dismissed.
Okay.
Then we file miss case. Again, that has been dismissed.
Okay.
Then very interesting part is we also file miss case staying the execution proceeding till outcome of the appeal which we are prefer, but that has been again dismissed. And we filed regular second appeal that has been withdrawn, and now we came up with this civil revision petition.
Against which order? Against which order?
Against the all the
Where is the impugn order?
order court passed by the court below.
Which order you are impugning?
We have impugned the order. Kindly see page 49. That is the original order which has cropped up.
No, which order you are impugning in this?
In the civil revision petition,
Yes.
yes, 6/6/2022, the ex parte judgment.
Where is the impugn order?
Kindly see page 49, Lordship.
This is the impugn order.
This is the impugn ex parte proceeding, ex parte judgment.
You have not preferred any appeal against this.
We have prefer that order will Lordship may see. Kindly see our petition, my lord, before that. This is a petition which we
No,
filed. Page,
Mr. What is your name?
my lord, N.K. Mori, my lord.
Mr. Mori.
Yes.
The order which you have annexed at page 49.
Yes, my lord.
Have you preferred any appeal?
Yes, my lord. Page 85.
What happened to that appeal?
Dismiss. Appeal dismiss.
Then against that dismissal order?
We have filed RSA that was withdrawn. And in the meantime, there is one miss case. Kindly see, my lord, miss case number, miss
No.
appeal.
Don't confuse the court. You answer my queries, which I am
Yes.
against the dismissal order of the appellate court.
Yes.
Have you challenged that dismissal order?
Dismissal order, we have, my lord, kindly see miss appeal number 9, 2024.
Where will I see?
That is at page 114.
This misappeal was preferred against which order? Ex parte order?
Ex parte dismissal.
Okay. Against this order, you have preferred any revision? This dismissal of miss appeal?
Appeal.
Yes.
No.
Then how can you agitate against the original order against which you have already preferred an appeal?
That appeal has been dismissed.
Yes, you have.
And we filed RFA, regular second appeal.
But that has been withdrawn.
Withdrawn.
Yes. And thereafter you have not challenged the appellate's court order.
Therefore, we are now in revision, because again
In revision, impugning
another proceeding also there in the execution.
revision impugning what? Impugning the original
And
ex parte order.
as well as this appellate order. Only our prayer is, at least we may be given liberty to file our written statement, because it is an inherited property, inheritance property. We have very limited prayer.
No, the question. Who were the plaintiffs?
Plaintiffs were now the respondents here in the
No,
CRP.
respondent number?
All the respondents.
So whether notices has been
My lord, notice yet effective. Last occasion respondent 1 appeared. Other respondent notice is yet affected.
heard, Mr. What is your name?
My lord, NK Muri, my lord.
NK Modi, learned counsel for the petitioner in CRPIO. In CRP. On perusal of the office note dated 16/6/2026, it appears that notice issued to respondent number 9 to 15 has been. How many respondents are there?
Yes, my lord, here are, my lord. 32, my lord.
9 to 15 have returned without any postal endorsement on the same, whereas in respect of notices issued to other respondent, the service report is awaited. The petitioner is directed to take fresh steps for issuance of notice on all the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 5th of August. In this, IA is for?
IA is for, my lord, regarding that execution part, we have brought it on record. And we are praying that at least, my lord, some, my lord, order may be passed so that, my lord, we may not be affected, my lord.
When is the next date fixed in the execution case?
Execution over, my lord.
So if it is over, what you want?
That is the problem, my lord. The problem is, my
You
lord,
don't tell the problem, you tell me the solution.
Yes, my lord. The problem is, my lord, since we also not pray any stay in this CRP, execution proceeding was carried out in the during pendency of the CRP. Now, out of 3 schedules I have already submitted, A, B, and C. A and C, we are not affected, though execution carried out. We are still in possession. And only schedule B land, some.
Now, whether any execution proceeding is pending?
No, my lord.
Oh. Then this.
Therefore, I am saying that, my lord, it is something because tomorrow if they sell the land,
Then we are not issuing even notice in this IA.
But at least, my lord, as a, my lord, as an ad interim protection, my
We
lord.
are dismissing this IA.
My lord, at least some observation that will be whatever execution carried out may be subject to the outcome of the proceeding, my lord, at least.
No execution is pending now.
No, whatever execution carried out.
No orders on this. When is the next date? If any execution case is filed, you can approach this court.
Now, I can understand, my lord, but problem is there, my lord. That is why we filed this petition. Because tomorrow, because it is an inherited property, tomorrow they will sell out.
Not Mr. N.K. Mori. Issue notice to the respondents. The Petitioner shall take steps for issuance of notice similar to the IA. Next date is 5th of August.
My lord, at least observation may be made
No observation.
so that, my lord, no prejudice may be caused, my lord, to the litigant, my lord, at least.
No observation is required. There is nothing pending.
No, no, at least what if suppose if my CRP is allowed, if de novo trial is taken place again,
If they are the decree under
if in the meantime, if the property is sold out, that will be again another problem, my lord.
you come with proper petition. This order 41 rule 5 is not maintainable.
I can understand, my lord, but there is no
Then-
other option, my lord.
There are other options. You do your research properly.
Because execution has been carried out. That is the problem.
Remaining items are to be left over.
Applies, my lord.
Item 21, I am for the respondent. My lord, the interim order is against me. Can it be taken up just after vacation, my lord? The date may fix.
No, the dates will be given by, we will request the registry to fix dates. Remaining items shall be shown as leftover. We will request the registry to
Well,
fix.
interim is there, well, regarding
Interim shall continue
Ma'am.
wherever there are
lot.
interim.